order was passed and the interim order was refused. And my other bids, 5 bids I submitted, that may all be rejected because of the passing of the blacklisting order. I've already filed it number at 2 o'clock, Lordship.
Okay. 1 minute. At 2, do you have a sitting?
There are 3 benches are there, but the judgments are to be delivered.
At 2, I have a.
Well, there are 2 benches are there, but they are all judgments are to be delivered. So, at any bench, Lordship will have.
Okay.
As per your Lordship convenience, whatever is.
There will be some inconvenience. You. Okay.
I'm highly obliged.
Please, Lord. But I beg to mention item number 4. In this case, we are having some development project. So the client is asking us to take some time.
Who's your client?
Numulga refinery.
Your good name, please.
M. Google.
On request made by Google and the Council for the list after
3 weeks.
so you want a 3 weeks or you want a date?
I wanted it.
Okay. 25th
All
January.
right.
My lord, item number 10, we have filed an affidavit, my lord, that may be called for.
Okay.
May I please?
Yes.
Okay, I beg to mention item number 3 of today's list, my lord.
Oh,
On behalf of the respondent,
oh.
my client seeking a little accommodation only for today, my lord. But may I pray, my lord, let the matter be listed immediately after the vacation.
You have,
I'm for the appellant.
Appellant.
do you have any objections?
My lord, if I may just pray for efficacy, that's all.
Okay. But Mr.
BD Decam.
B.D. Degal and the council for the appellant on request made by Mr. Babu Jared and the standing council,
Revenue.
Revenue Department. List on 21.
5th, my lord.
Well, can it be on 5th of January, my lord?
Okay.
Obliged.
So obliged.
Item 1 for motion.
May it please the Lordship. Lordship, this PIL is filed against the cutting and selling of the Agarwood trees, Lordship, in the campus of Amguri College, Lordship, and by one professor. And in this regard, Lordship, in the government meeting also, there is a discussion regarding this. And the petitioner came to know about this, Lordship, by filing a RTI, Lordship. The petitioner is the president of an NGO, Amguri Navanirman Samiti, Lordship. And in this regard, petitioner has also filed a representation before the Superintendent of Police, Lordship, Vigilance and Anti-Corruption Department, Lordship. And accordingly, the respondent has directed the SP, Sipsagar, to take necessary action against it, Lordship. But that has not been done yet, Lordship. So my humble prayer to only take against the representation, Lordship, whatever the petitioner has been submitted, Lordship. That is, Lordship, Annexure C is the representation before the Superintendent of Police, Vigilance and Anti-Corruption Bureau, Lordship, page number 47, Lordship. The petitioner filed this representation and accordingly an action has been taken by the Superintendent of Police, Vigilance Anti-Corruption Department, that is Annexure E, page number 51, Lordship.
This one. Just subsidies before the Superintendent of Police. Yes, so what do you want?
Lordship, my humble prayer is to just take a necessary action against this annexure E, Lordship, that has been directed to the SP Sibsagar, Lordship. Inquiry committee has to be held, Lordship, in this, the illegal cutting and selling of the Agarwood trees, Lordship, because it is impact the environment as well as the huge financial loss of the public of the Amguri, Lordship.
Yeah, who appears?
First of all, illegal cutting and selling of the trees, that is under the forest department.
Hmm.
And secondly, this is under the college campus.
Hmm.
This is a college institution, because they have not filed any representation before the college higher authority or governing body or principal. The police has nothing to do. What the police can do, madam?
Direction is there,
This is
Lordship.
if any trees are cutting or selling, this is under the forest department. They have to lodge a complaint before the forest department.
Lordship, it has
But then
been,
the superintendent of
yes,
vigilance and anti-corruption
My lord.
has written to the superintendent of police.
The-
Sivasada.
That is another part. So vigilance part is different. If any allegation against that person concerned, that is looked after by the vigilance. This is different part. But cutting and selling of these trees, that should have to be, my lord, under the control of forest department. This is my learned friend said this is my valuable agar tree. If that is so, then why not they go to the appropriate authority?
Have you met any representation before the forest department?
forest department, no, Lordship.
Yeah.
The college,
This
If
PIL is not in a proper
chief
form.
security. Lordship, direction is there to take necessary action, whether there is.
That is one part.
Yes, Lordship.
But for the cutting of the trees,
Yes. This is a main allegation.
This is the
have
meaning.
you represented before the forest department?
Not yet, Lordship.
Then you'll have to represent. And if no action is taken, then you can come back.
Lordship, I only pay to consider my representation, that's it, Lordship. If the
Who will consider lordship representation?
Now, where's your representation?
Lordship, whatever this has been forwarded to the SP Sagar, that has to be taken action, Lordship. That is my favorite. Just to inquiry whether there is a cutting or selling that is going on. That has to be inquiry, Lordship.
And DC also not made a party, my lord. He is a district magistrate. If any problem, any allegation against any institution, this is the district magistrate. He is to look after that. Nothing, my lord. This is not a proper format.
There's a lot of defects in your PIL.
Lordship, and
What we can do, we can dispose of this PIL directing with representation to the forest department. In the meantime, something the police also will take steps in terms of the legislation, something like that. We'll dispose of this PIL directing you to make a representation. In the meantime, superintendent of police.
Yes, before appropriate.
Lordship, Lordship, will file the representation before the forest, and as well as Lordship may pass an order to dispose our representation, that is annexure E, which has been directed to the SP, Lordship, that also taken into consideration, Lordship.
Heard MS,
M. Nirula, Lordship.
L. Nirula, Learned Counsel for the petitioner. Also heard Mr.
Okay, madam.
R.K. Bora, Learned. Yeah, the government.
Additional senior government.
Additional senior government advocate for the respondent number
That's 125.
1 to 5. Stop. In the present PIL, the petitioner is alleging that one Trilochan Bora, who is a professor of Amguri College, is cutting and selling Agarwood trees, which are planted within the boundary of the college, Amguri College campus. Stop. the petitioner came to learn about this through an RDI application, which was made on. When did you make your RTI application?
Lordship, RTI application, but it came to know on the governing meeting 3/4/2023, Lordship.
The petitioner came to learn about this with regard to the reply made by the petitioner. Now, with regard to the reply, with regard to the RTI reply made by the petitioner on 3/4/2023. Stop. Accordingly, comma, where's that representation before the vigilance?
Lordship, 11/4/2023, that is page number 47, Lordship.
Okay. The petitioner made a representation alleging illegal sale of agarwoods, agar trees of Amguri College on 11/4/2023 before the Superintendent of Police, comma, Vigilance and Anti-Corruption, Gurio, Assam. Stop. Consequent thereto, comma, the Superintendent of Police, Directorate of Vigilance and Anti-Corruption, forwarded the complaint of the petitioner by forwarding letter dated 29/5/2023 to the Superintendent of Police, Sivasagar, Assam, to take necessary action. Stop. The petitioner is aggrieved that the Superintendent of Police, Sivasagar, Assam, oblique respondent number
Lordship,
5
five.
is still not taking, any steps. Stop. Para. On the perusal of the materials available on the court, we find that the petitioner has made no representation before the Forest Department, Assam. Stop. Stop. Accordingly, comma, this PIL is disposed of, directing the petitioner to make a representation before the Forest Department.
Yes.
Is it Forest Department or what?
Yes, but my lord, this forest controlled by the forest
Before
department,
the,
DF,
Forest-
DFO,
before the Forest Department. Within a period of
A month, Lordship.
1 month, you take to file a representation. Take 2 weeks, within a period of 2 weeks from today. Stop. In the meantime, the respondent number 5, oblique, the Superintendent of Police, Siva Sagar, is also directed to take steps in terms of the letter dated 29/5/2023, written by the Superintendent of Police, Directorate of Vigilance and Anti-Corruption, Assam. This
one more thing,
PIL is
my lord,
disposed of.
they have made an allegation against a particular person, but he is also not a party.
Yeah.
Item 2.
This PIL
Right.
is reported.
May I please, your lordship?
Contempt,
Lordship,
who is the order?
it starts from page 19. The operative part is at page 21, my lord. The last paragraph. Mr. So-and-so learned counsel for the appellant has also submitted that as per direction number 4 issued by the learned single judge, the Deputy Commissioner, Kamrup Metro and GMDA shall deposit cost of rupees 50,000 in the registry today. Mr. So-and-so further submitted that the amount of rupees 1,25,000 as per the site verification report shall be paid to the original petitioners within a reasonable time, which in our opinion should not be on or before 31/1/2023. Similarly, the direction number 1 for putting the original petitioners back in possession of a decretal land shall be complied by the Deputy Commissioner, Kamrup Metro and GMDA before 31/3/2023. Now, so far the monetary compensation is concerned, Lordship, that has been deposited and the concerned petitioners, they have already withdrawn it. Now, so far the land is concerned, my lord, kindly come to the next page, Annexure 3. On 31/3/2022, the circle officer, Guwahati Revenue Circle, he writes to the ADC Land Settlement Branch. This is a translated copy, Lordship. The original is next to it. With due respect and in reference to the subject cited above, I beg to inform you that the plot of land covered by DAG number 1644 Moja, Guwahati Village, Sohar Guwahati Part 2 is part of Borsala Bill. The land covered by the said DAG has been preserved and reserved for Guwahati water bodies. White Gazette notification issued in 2008. Enquiry and search is going on to settle, hand over some other land to Sri Dilip Kumar Dutta. Presently, there is no land in the said DAG which can be handed over. So this was issued to the ADC on 31/3/2023, Lordship. So since then, we have been regularly meeting the officers. We've been going to the inquiring. There's nothing forthcoming, my lord. They have simply sat on the order passed by this court. So my humble submission, Lordship, that is why
But Mr.
A. Sharma.
The council for the petitioner issue notice. Petitioner to take steps for service of notice on the respondents 1 and 2 by registered post within 1 week. 1 week
Lordship,
is after 6 weeks.
obliged.
Item 15 from supplementary list.
May I please, Lordship? Lordship, matters related to Surface Act, Lordship. In the year 2017, Lordship, the petitioner has availed a cash credit of rupees 4,80,000 and 50,000, Lordship, as a term loan, Lordship. And the said loan was secured
How much?
4,80,000. Lordship, kindly come to page, Annexure 1, page 17, Lordship. Page 17, Lordship. Right, term loan, Lordship, sanction limited, 4,80,000. And another term loan, Lordship, account number so sanction limit 50,000, Lordship. Total, Lordship, 5,30,000, Lordship. So therefore, Lordship, they issued the sale notice on 28/11/2023, page 19, Lordship. Next page 19, Lordship. Sale of e-auction of the immovable property, Lordship. Here they are showing that, Lordship, kindly see second para, Lordship. Symbolic possession has taken 15/2/2022, Lordship. Will be sold as is, where is, as is, what is, and whatever there is on 3/1/2024. Date fixed for e-auction for recovery of rupees 4,24,728, Lordship. So, and the reserve, next page, Lordship, they have written that reserve price for the property will be rupees 13,96,805, Lordship. And honest money, Lordship, 1,39,000. So now, Lordship, here the land and building which is secured by the loan credit at the time of taking the loan, Lordship, is the land and building is situated near the just boundary line of the Tezpur University, Lordship, which is very valuable, Lordship. And it is the only one property of the petitioner, Lordship. He availed this loan only for the development of his wooden furniture shop, Lordship. And before COVID-19, Lordship, he was regularly paid the amount dues, Lordship, monthly dues along with interest, Lordship. But after COVID-19 pandemic, Lordship, there is some irregularities, Lordship, due to loss of the business, Lordship. Petitioner is ready to pay all the amount, Lordship, like one-time settlement or allowing him some time, Lordship, monthly dues, Lordship. But now they responded after this, yeah, they are taking, Lordship, for taking the petitioner's land and building, Lordship, through e-auction, Lordship. So my humble submission, this, Lordship, kindly state the order dated 28/11/2023 and 30/11/2023, Lordship.
Ganguly,
Lord, the outstanding dues is not a big amount.
you want the land or the money?
Lord, we want money. We are not concerned really with land. If it's a small amount, if he is willing to pay, my lord, but he has made a very dangerous statement at para 14. Your lordship will kindly have. That kind of statement, my lord, creates a little bit of a doubt. Page 12, para 14. primary read, my lord, he says that the petitioner begs to state that it is not the case of the petitioner that he will not pay the settled amount. That he needs some time to continue his business, and if his business continue, he will pay the aggrieved amount within a period of 1 year in installment. Well, this kind of order, my lordship, my lord, into 26. This is not reschedulement. This is not the correct forum, my lord, first of all. In fact, there is no such forum at all. What I would suggest, purely, my lord, of the act, is that it's a very small amount in dispute. If he agrees to pay a substantial amount, today we are on 21st December. Auction is scheduled on 3rd of January. If he pays even before the auction, but he should pay. What happens, my lord? These auctions are not conducted by us directly or physically. These are conducted by a third-party agent from Delhi, my lords. And we have to intimate them to cancel it at least 24 hours in advance. If he pays, let us say by the 1st of January, my lords, some amount, which your lordships, I leave it to your lordships to decide, my lord, what would be, because it's a very small amount. Let him pay, my lord, at least, let us say 50% of
How
payment.
much can you pay?
Lordship, just I may allow, as per the condition of the petitioner, lordship, I have taken the instruction. Just 4 weeks may be granted to pay him, lordship, some amount, lordship.
4 weeks.
4 weeks maybe, lordship. He is managing some amount, lordship, as he is the very.
No, how much is the total outstanding due?
Not much, my lord. It's around 4,24,000. Yeah, they have written 4,25,000, lordship. 4,24,000, lordship.
Where is that?
Well, that will, lordships will find it page 19.
In the notice?
Yes, page 19. 19 and 20, lordship.
It's not a big amount.
Not a big. But seeing the condition of the prisoner, the only layman meaning is he is the only one property, lordship. He is somehow he will manage, lordship, and 25% maybe he will deposit the lordship. 25%, lordship.
When?
2 weeks, 3 weeks, lordship may be given, lordship. Before, lordship, vacation, lordship, you provide it, lordship. In that case, my lord, what I would pray is that the auction may be allowed to proceed, but confirmation will not be done. I'm ready to pay. What happens is that when these matters go to the tribunal, my lord, the tribunal passes that kind of order that you deposit a certain percentage before the auction date. The confirmation shall be stayed subject to deposit. My lord, tomorrow if he doesn't make the deposit, then, my lord, the auction fails, and again I'll have to put to property. Again, my lord, I'll have to also incur an expense. Ultimately, he has to pay the entire thing. So this is a case where the property value is more than the outstanding amount. I'm ready to pay, lordship. This honorable court has the right and power, lordship, listed the order, lordship, and I'll pay, lordship, before, lordship, 10th of January, lordship. As per.
Then they'll have to proceed with the auction without confirmation.
Or, lordship, then I'll, as far as possible, lordship, I will pay, lordship, before the 3rd of January, lordship.
When can you pay? 2nd?
2nd January, lordship.
How much?
Then regarding this, lordship, may I take some instruction with the.
You've not come with instructions. I told you.
No,
It was on your mention yesterday.
Yes,
That
lordship,
we're
I
lifting
take-
it today.
Lordship, 20%, lordship, I will pay, lordship. 20%, lordship. I would pray that he pay it by first, because otherwise what happens is that if he pays, if he doesn't pay or he pays on 2nd, if I inform on 2nd, auction will go through.
First is a holiday.
Yes, lordship. Let him pay. Let him pay on 2nd, by 2nd, that's 2nd January. 25%. 25% of what the outstanding as per the sale notice. 1 lakh. 1 lakh. 20-25%, lordship, maybe.
Heard, Mr.
NH Lashkar.
The counsel for the petitioner. Also heard Mr. A. Ganguly. The standing counsel,
Lodge.
standing counsel, Punjab National Bank.
Lodge.
For the respondents, 1, 2,
All the respondents.
for all the respondents. Stop. The petitioner took a term loan of rupees 4,80,000 on 1/4/2021, correct?
No, that is the, my lord,
When did
date
you
of
take the-
entry.
when did you
Date,
take the
lordship,
loan?
Sanction letter, they have not provided to the petitioner lordship. Sanction letter and up-to-date lordship, bank statement lordship. While the petitioner went to the respondent number 4 and 3 in their bank lordship. After getting this, after
We have the
this-
mobile app.
After
PNB
this,
one, he can go in and obtain entire statement free of cost. Nothing is required. What in which
Bearing
world is
account,
living?
bearing account number. Don't say on, huh? 1866. This we see in the page 70. 4 zeros, 2813. And another term loan of rupees 50,000. Bearing account number 1866 0000 02073. Totaling to an amount of rupees 5, 30, 000. 5,30,000. Stop. The petitioner was paying the interest amount till the onset of COVID-19. However, as his business, as there were some problem with his business, he defaulted in paying the interest loan. And accordingly, the respondent bank issued sale notice for sale of immovable property on 28/11/2023 for an amount of rupees 4,24,728.31. On the basis of, within inverted commas, you say, S is where is, comma, again inverted comma, S is what is, and within inverted comma, whatever there is on 3/1/2024. Stop. But learned counsel for the petitioner submits that the petitioner is willing to pay 25% of the outstanding due, i.e. rupees, of the outstanding due on or before the 2nd of January 2024. Stop. Then you stay the auction. Stop.
Subject to deposit.
Subject to? No. Stop. Recording the submission made by the learned counsel for the petitioner, comma. Petitioner is directed to pay 25% of the outstanding due to the respondent bank on or before 2nd of January 2024. Stop. Stop. Accordingly, comma, the sale notice dated 28/11/2023 issued by the Chief Manager, Authorized Officer, Punjab National Bank, shall remain suspended, subject to payment of the said.
Solicitor also, another was 30/11/2023 lordship. One is grantor and another is present petitioner lordship.
Where?
30/11/2023 lordship.
And the sale notice dated
And page 20 lordship.
dated 28/11/2023 and 30/11/2023 shall remain suspended, subject to payment of the said 25% against the outstanding due. Stop. List the matter again on when?
Lordship. 10th of January lordship.
Okay, 10 January.
Highly obliged.
Ladies item 5 for admission. Lordship, I have in my possession one judgment passed by Honorable Supreme Court pertaining to a tender matter, and it is very relevant to my writ appeal. And I have been saying repeatedly that there is a hidden agenda so far state respondent is concerned. These small estimates are being clubbed, not practical requirements, not technical necessity. It was done in the interest of top competent authority. There is a hidden agenda, and Honorable Supreme Court has very clearly said,
Did you participate in the?
no, Lordship, participation is not possible because they have made the group bigger. If the group would have been limited permission, then we could participate.
In fact, Lordship, without Lordship's observation in the last occasion, Lordship, his locus, Lordship, when the matter was discussed. And moreover, Lordship, the process is already completed, Lord.
Lordship, I may
The whole
kindly,
process has been completed. The
Lord-
matter has become inspector's, Lordship.
Lordship, I mean, this locus is not being challenged over here. Locus is the issue of the trial. I mean, it's a single judge matter.
Locus, this court is raising the issue of locus.
No, this,
It's
I
not the
am,
question of not the issue here. We
Lordship,
are raising the issue of locus.
kindly issue this.
So you'll have to satisfy this court.
No,
Whether
no.
you have the locus.
Lordship, my submission is, I am challenging the order of the Honorable Single Judge. Honorable Single Judge did not mention the issue of locus. He dismissed the writ petition. So kindly peruse these two judgments.
The locus, he didn't participate in the tender.
So the whole process has been completed now, Lordship.
Process is different. Process completion, irregular process always can be challenged. Para 26, para 27, 28 and 41.
Hmm. What is judgment? Have you seen the judgment? This is with regard to those who participated. Not this. You get some other judgments. This is for those who have participated in the tender.
But I am challenging the hidden,
Read it. Para 26, read.
then I am giving him another judgment if necessary. Give me another time.
Okay. On request made by Mr.
P. K. Bhattacharya.
No, petition person, list after. When do you want?
After vacation,
After vacation?
10th of January. Or
Let it be after the Bihu vacation. 24th January.
After my name may be recorded, Lord.
Mr.
N. Upadhyay.
N. Obade, Leonard Standing Council, Irrigation.
Right.
Leonard Standing Council appears on behalf of the Irrigation Department.
All right, Lord.
Item 6.
May it please your lord. My lord, you will find, my lord, that this is an appeal, your lordship, against the impugned judgment and order passed by the learned single judge, your lordship will find at page 149, your lord.
What?
149, your lord. Now here in this case, my lord, the writ petitioner, my lord, he was superseded, my lord, by the respondent number 5. In the matter of, my lord, appointment to the cadre post of the LD assistant, and so also in the case of promotion to the post of UD assistant, your lord. Now, learned single judge, my lord, dismissed the writ petition primarily on the ground that the writ petitioner has retired from service, your lord, during the pendency of the writ petition, and as such, no reliefs could be granted to him, your lordship. And in this way, your lordship will find the learned single judge, my lord, ignored the decision of the Honorable, my lord, Supreme Court, my lord, Supreme Court of India, in the case of MP Singh Bargati versus, my lord, the state of Madhya Pradesh, your lord. Now, my lord, this is the first, my lord, my ground in the appeal, your lordship, that after retirement, my lord, if it is found that while the petitioner was in service, my lord, he has been superseded by his junior, then, my lord, he could be given the notional promotion, your lordship. for the purpose of pensionary benefit to the writ petitioner. Now, this aspect, my lord, was totally ignored, your lordship, by the learned court below, your lordship. Secondly, your lordship will find, my lord, learned single judge in passing the, my lord, impugned judgment and order, your lordship, have, my lord, ignored Annexure 14, your lordship, at page 65, your lord. At page 65, your lordship will find, my lord, the petitioner, writ petitioner, my lord, was admittedly senior to the respondent number 5, your lordship. Now, page 66, your lordship will find, Vikas Ranjan Som, he is the writ petitioner, your lordship,
When did you superannuate?
my lord.
When did you retire?
30/11, my lord, 2015, your lord. 13/11/2015, during the pendency of the suit, my lord, writ petition. Now, the learned single judge, my lord, in passing the, my lord, impugned judgment and order, ignored this, my lord, seniority list. Now, admittedly, my lord, as per this Annexure 14, the, my lord, writ petitioner was senior to the, my lord, respondent number 5. Your lordship will find at page 66, writ petitioner at serial number 10, and, my lord, the respondent number 5 at serial number 15, your lord. Now, learned single judge, my lord, in passing the, my lord, impugned judgment and order, also ignored, your lordship, the standing order of this honorable court, that if it is found, my lord, that a particular, my lord, junior has been, my lord, promoted or superseded, my lord, then this senior, my lord, would be promoted at least one day ahead of that of the junior, your lordship. And that, my lord, order, my lord, had attained finality, your lordship will find Annexure 9. Page 48, your lord. 48, your lord. Now, 48, your lordship will find, my lord, that order, your lordship, at page 48, Nikhil Chandra Das. He was similarly situated in the department, my lord. And when, my lord, this respondent number 5, my lord, he superseded, my lord. Nikhil Chandra Das, he came before this honorable court, my lord. And court said, my lord, your lordship will find, my lord, at page
'It starts from 9. 9, 10, and 11. You read para 9, 10, and 11 of the judgment?
there are
9, 10, and 11.
9, 10, and 11 of the judgment here.
Page 153.
I am coming to this, my lord. Now, my lord,
No, you first read it.
my lord, paragraph 9. Now, court, my lord, relied on this particular judgment, your lordship, at Annexure 10 of my petition here. CR 6384 of 1996, your lordship, will find from Annexure, my lord, this particular one. Now, this judgment is no longer, my lord, in my lord court. A writ appeal was filed. And the writ appeal, my lord, honorable, my lord, division bench said we should file our individual representation, my lord. In this particular, my lord, CR 6384 of 1996, association has come. There are several people with different particulars. Now, my lord, the Annexure, my lord, 11-year lordship will find writ appeals order. Court said you ignored this judgment of the learned single judge. You should not be influenced by the judgment of the single judge, your lordship. And the authorities to pass their own, my lord, findings, my lord, or order, my lord, without being influenced by this particular, my lord, CR number 6384 of 1996, what is mentioned in paragraph 9, your lord. Now, my lord, the court has not gone into this, my lord. I take your lordship to Annexure 11, your lord. At page 55, your lord.
You are not reading what we are asking you to read.
My lord.
You are going on a different line. We are asking you to read para 9, 10, and 11.
Paragraph, my lord, 9, it is not a dispute that during the pendency of the writ petition, the writ petitioner as well as respondent number friend attained the age of superannuation, my lord. And they have retired from service. In so far as the claim of the petitioner on being absorbed to the post of LDA with effect from 1/8/1998, that is the date on which he was regularly absorbed and extradited is concerned, the said prayer was made in CR number 6384. Petitioner did not, my lord, came in association came. Petitioner was the assistant secretary. He represented, my lord, so his name came. So 6384 instituted by the writ petitioner as the assistant general secretary of All Assam Extra Writer Association. However, the prayer made by the petitioner was declined by the learned single judge by judgment dated 14/9/1999 by holding that the writ petitioner was frivolous and misconceived. Even the writ appeal bearing number so and so preferred by the petitioner was withdrawn by order dated 21/2006 with liberty to furnish particulars of the individual seeking relief before the competent authority. Mr. Sen submits that the client had submitted a representation and was awaiting the outcome of the process before the departmental authorities. Be that as it may, the facts remains that the writ petitioner has unsuccessfully agitated the same issue in the earlier round of litigation before this honorable court. Therefore, the issue as to whether the petitioner has a right to be absorbed in the cadre of LDA with effect from 1/8/1998 is no longer open to debate, therefore cannot be gone into this present proceeding, your lord. So court relied on, my lord, this annexure 10. Here, my lord, 6384 of 1996 is annexure 10. And against this, my lord, an appeal was filed, my lord. Now, what is the appellate order court had gone into, my lord? Now, it further appears that respondent number 5 was regularly absorbed and extradited with effect from 1/8/1988. On the strength of the order dated so and so passed by the learned single judge in civil rule number 8402 of 1995. Now, earlier order that this honorable court passed, my lord, annexure 9, my lord, I have stated, the court said this kind of order cannot be passed. Court said that if there is an order from this court that junior is to be my lord, promoted or absorbed earlier than the senior, then these sorts of order cannot be passed. So that was also overlooked, your lordship. Now, thereafter, the respondent number 5 was promoted, absorbed in the post of LDA, but such absorption in the of the respondent number 5 as LDA is not under challenge. That is also not correct, your lordship. We challenge his, my lord, appointment to the post of, my lord, LDA. In this years in question, your lordship, annexure 10, our writ petition or the writ petition filed by the association, my lord, was dismissed, no doubt. But that did not attain finality, your lordship. It has gone into an appeal. An appeal said, my lord, your lordship may kindly turn to annexure 11, my lord.
How can it not attain finality?
Annexure 11 at page. 55, your lord. "55, your lordship. This is the appeal, your lordship. Lastly, your lordship will find page 57. Now, my lord, first page 56, my lord, appeal. The appeal has been filed by the All Assam Extra Writer Association, Karimganj District Unit, challenging the validity of the judgment and order dated 14/9/99 passed by the learned single judge of this court, dismissing the writ petition civil rule number 6384 of 1996. So against this, my lord, order passed in the, my lord, writ petition or civil rule, my lord, 6384 of 1996, an appeal was filed. Now, in the appeal, the court said, my lord, page 57, it will be difficult for the, my lord, I am reading second line, it will be difficult for the respondent to answer the contents raised by the petitioner association with reference to each of the members of the so-called association. If at all they have any grievance, the individual employee alone could have maintained the writ petition by providing materials in support of the respective case as to how they are senior to the respondent number 5 and 7, 5 to 7. In absence of such particulars, we cannot rely on the annexure annexed to the writ appeal. Necessary particulars are required to be furnished, supported by affidavit, so that respondents could verify the particulars of each of the applicants before taking appropriate decision in the matter. Faced with such a situation, learned counsels for the appellant has sought the leave of this court to withdraw the writ petition and the writ appeal with the liberty, my lord, to approve the department making appropriate representation.
Lordship, my lord, already been clearly stated in the paragraph 9, 10, and 11. Lordship, in the, my lord, single bench judgment. My lord, earlier, my lord, he said that he is a senior. My lord, he never been, my lord, approached before this court, my lord, that challenge the appointment of the respondent number 5, lordship.
So respondent number 5,
Never
my
been
lord,
challenged this
appointment
before.
was
This
challenged,
petition was
my
filed
lord, in the writ
on behalf of the, my lord, all Assam, my lord, Extra-Writers Association,
Now,
not by the individual, lord.
ultimately, my lord, court said, page 57, last paragraph here, lord. Leave is accordingly granted in case the appellant approves the department with such representation duly furnished by the individual particular, respondent shall pass appropriate order without being influenced by the order passed in the writ petition.
So will issue notice.
Lordship, my lord, can we see the writ petition as well as the writ appeal? It was filed by the on behalf of the all Assam, my lord, Extra-Writers Association, not by the individual,
But
lordship.
Mr. Endar, isn't
Aye.
it? Then it comes over to appellate. Mr. J. Hendrik, then it's standing counsel,
For respondent 1, 2, and 3, lord.
Revenue Department.
Lord.
Appears for 1, 2, and 3. Who appears for 4? Mr. Arbor, Leonard, additional senior government. Appears for responding 4. Stop. Issue, petitioner, appellant to take steps for service of notice on the respond number 5 by registered post AD within 1 week. Please, after 4 weeks.
Item 7. Offline.
Right, please, your lordship. Filing the certificate, my lord, telling the impugned order dated 21/1/22 as in WPC number 10 of 22, my lord. My lord, petitioner appellants are, my lord, diploma holders, my lord. They were appointed for direct recruitment, my lord. And on the basis of Central Pay 6 Pay Commission, my lord, similar benefit of higher scale of pay granted to the overseers and superintendent to in the border organization, my lord. Same has not been granted to the petitioner, my lord. That is why we paid highly petition before a single judge that has been rejected. At this stage, my lord, I pray for issuance of notice to the respondent, my lord.
Who are doing the respondent?
My lord. Official respondent, my lord.
Yeah, appearing on behalf
Yes,
of all,
On the respondent.
then everything. Let admit it. Oh. But Mr.
H. Rahman, lordship.
H. Raman and a concept admit. MSc Gyan, Leonard CEC, and this appearance on behalf of all the respondents. No. List after 4 weeks.
Obliged, lordship.
That's complete.
Item 16 from supplementary list.
May it please your lordship. In a very abnormal situation, this appeal has been filed, lordship. It is not under normal circumstances. The basic background, or in a nutshell, the facts is that, lordship, once Sri Monsoon Borkakoti, she cleared her examination recruitment process and she was appointed in the Assam Revenue Service and she was working in 2019 onwards. Then a complaint came from APSC as well as some other third-party NGO that she was or she is not a OBC candidate, she is a general candidate. Immediately, as per the procedure, a committee was constituted and she appeared before the committee also. And before the committee also, she said, my father is a caste, general custom, but she stayed with her mother, who, according to her, is a coach candidate, OBC candidate, but she resided in a post locality in Jorhat. Under this Supreme Court guidelines, Lordship, that Madhuri Patil's case, whenever this kind of inquiry takes place, the opinion of the vigilance officer is most critical. She came and this committee opined that her OBC candidature is not correct and they have rejected her OBC certificate also. The Deputy Commissioner issued the cancellation certificate. And thereafter, she was put to suspension also. They came and filed a writ petition, and the writ petition, Lordship, the order was that the inquiry was not done as per the procedure, and the Honorable Court fully relied upon the opinion given by the vigilance officer. Thereafter, that order was passed in November last year, and she was still not put, the suspension was not revoked. She came before the Honorable Court, and on 17th of February, the Honorable Court said that as her original the inquiry went against her, but as the single judge has turned down and set aside the inquiry findings, so she should be immediately reinstated, because till that moment the state has not preferred the appeal. File came to various agencies of the government, Lordship, and it was opined on 19th of May that an appeal should be filed by the state of Assam. On 14th of June 2023, the Chief Minister said that immediately appeal should be filed, and it was forwarded to the Advocate General's office. When the appeal was prepared, the state government came to know, the senior government came to know that the third party who complained, they had filed an appeal, and that was dismissed on 1st June. Before the government could file the appeal, the third party came before this Honorable, and the Honorable Court upheld the learned single judge's order. In that situation, the order of 17-2, where the suspension has to be revoked, order was passed. That was in position. And therefore, as she was not reinstated, a contempt petition was filed. In the contempt petition, today the date is fixed for giving the sentence. Day before, 2 days ago, the Honorable Learned Single Judge found that there is contempt, and contempt proceeding was drawn. And opinion has been found that there is willful and deliberate violation of the court's order. In that situation, why the state government has not implemented? Because in 99.9% cases, either we appeal immediately or we comply. It is normal case of reinstatement. But why we have not done it? The officer came before this Honorable Court, and there is a series of process we have undertaken. It has come to the notice of the highest authority of the state, the Chief Minister, because without the Chief Ministers, the reinstatement cannot be done. The officer have done his part. And when she was suspended also, the Chief Minister's approval was taken in 2021. The Chief Minister observed that there is a huge difference of the opinion given by the Deputy Commissioners Committee and the police officer. That was in June. So he directed the CID to do the inquiry. On 14th of November, the inquiry report came from the CID that the OC is not at fault, but the person who was conducting the inquiry at the grassroots level, at the vigilance officer, who had alleged that whole finding and whole opinion and whole records were all either fake or totally perfunctory. We have told all this to the Honorable Court. The Chief Minister said that you file a review application. We filed a review application before my Lord Justice Manoj Pathak and my Lord Justice Mitali Thakuria, because Mitali Thakuria, my Lord Justice Mitali Thakuria was part of the judgment delivered on 1st June, by which the appeal was dismissed with my Lord Justice, the then Chief Justice. The Honorable Court was convinced, issued notice, and fixed 5th of January for consideration of the interim prayer. That is the situation. In that situation, we brought everything to the knowledge of the learned single judge day before yesterday. In spite of that, Lordship, the direction has been issued that today the matter will be fixed today. We can file an affidavit regarding the sentence, and that matter is to be taken after some time today. So in that is the situation. Now I'd like to place the record. And the officer very clearly said before the learned single judge that I have done all the things what I have to be done. If the chief minister is not approving it, I cannot overrule the chief minister's direction. Chief minister must let me place it before this honorable court. Is 60. Because that is our whole edifice today. It's 60. This is a note of 17th December, hardly 3 days ago. It appears that the authenticity of the OBC status of Srimati Monsoon Borkakoti, ALRS, under suspension is in serious doubt. While I fully respect the majesty of the Honorable High Court, and I am committed to complying with the directions of the Honorable High Court, history will not forgive me if she is reinstated in service without final verification of her OBC status. Because a general candidate should not get the benefit. That is why this line is written. In this backdrop, a prayer may be made before the High Court to grant state governments only 15 more days to take a decision on either implementation of the order of Honorable High Court or to file a review application in the Honorable High Court or Supreme Court with the bona fide intention of upholding fair play and justice to all concerned. Further, so-and-so may be requested to accompany Tanmoy because he was personally appeared on the other day also during his appearance on the court and place the full facts before the Honorable Court as well as to submit that there is no willful lapse on part of Tanmoy Borgohai in complying with directions of the Honorable High Court. Further, a meeting may be convened on 20th. That was yesterday. So now I'd like to place the report of the CID. 125. These are all part of the court's record in the contempt as well as in the review petition. That report, Lordship, will kindly come to page 126. 31st July 2023. Submission of additional information with reference to the subject cited above as directed by the following have been submitted in addition to the report already put on 17 July. In pursuance of government OM dated page 126.
Yes.
In pursuance of the government OM dated 11/5/2018, a vigilance cell was constituted in the Directorate of WPT BC Department on 6/6/2019 to deal with the matter relating to fake caste certificates. The members of the cell are so-and-so, so-and-so, so-and-so. As per the mentioned memo, the then SP CID nominated Sri Satyakal Sangsan APS, the then Deputy SP CID, along with Inspector Jodu Malakar and Inspector Dibbojyoti Datta from CID Assam. This is as per the memo dated 24/6/2019. Sri Sanjeev Hazarika, Deputy Secretary to the Government of Assam, by letter dated 11 July 2019 to the Director of WPT and BC Assam, had requested to inquire the case status of Srimati Monsoon Borkakoti through the committee and submit the report accordingly. Sri Bibhas Chandra Modi, ACS Director WPT BC, by letter dated 30/7/2000 asked Inspector Dibbojyoti Datta of CID to verify the caste certificate of Monsoon Borkakoti. So this Dibbojyoti Datta, he had messed up the whole thing. Resident of Club Road, Jorhat. Inspector Dibbojyoti Datta had submitted his inquiry report to the SP CID on 3/10/2019 in response to the above mentioned letter received from Director of Welfare of Plain Tribes and Backward Classes. The detailed report in connection of the matter has already been submitted on 17 July 2023. The following observations are made. Number one, in the OBC certificate of Sri Monsoon Borkakoti by All Assam Backward Classes Association dated 13/11/2006 and countersigned by the then Extra Assistant Commissioner, Additional Deputy Commissioner Jorhat, in the name of mentioned as Monsoon Borkakoti. There is a discrepancy in the name, number one. That is not very important. Sri Digonto Borua, village headman of Sekoni Dhora Gaon, Jorhat, under whose jurisdiction Sri Monsoon Borkakoti currently resides, had provided a copy of the letter he received from Surendra Nath Bora. He is a Gaonbura of a district of Golaghat, where her father resides. The then village headman of Doi Rongia Gwalgaon, informing that late Siva Prasad Borkakoti, father of Santanu Borkakoti is the father of this girl, along with his family, was residing in Doirongia, Gwalgaon, Moja, so-and-so, Golaghat before 1950, and they belong to Kus community. Sri Surendranath Bora, the then village headman of Doirongia, Gwalgaon, denied issuing any such letter, confirming that they belong to Kus community, thereby contradicting the statement of Digonto Borua, village headman of Sekonidhara Gaon, Jorhat. So father is never a OBC candidate. He is a doctor now. He never took benefit, and he himself, she before the committee also stated, I belong to general caste. Those state records or everything is with us, Lordship. Sri Monsoon Borkakoti had received a letter dated 26 March 2019 from a Deputy Commissioner Jorhat asking her to bring the original documents for verification. Later, the aforesaid letter was found to be fake, for which R.A. Kakoti IAS, the then Deputy Commissioner Jorhat, had submitted a written complaint on 3rd April 2019 to officer in charge Jorhat PS against unknown persons for faking her signature and official seal. On receiving the complaint, a case was registered as so-and-so. The following points were not incorporated in the earlier inquiry officer Dibbojyoti Doctor of CID Assam in his report submitted to SP CID dated 3/10/2019. The above mentioned observations may be taken into account if it deemed fit in ascertaining the mala fide intent on the part of the previous EO, that is inquiry officer, submitted for your perusal. All these things have come into light now. And what is we have to do? We have to bring it to the Honorable Court's or notice. Lordships as well as the Chief Minister, they are all under oath of the Constitution to uphold the spirit of the Constitution. That is reservation granted by Ambedkar to the backward classes. A general candidate cannot be at any cost due to hyper-technicalities, Lordship, can be allowed to take reap benefit, which actually is not deserving. So now, this is the report, and therefore we filed the review application. And the review application, when the Chief Minister wrote this note, Lordship, on 17, which I have just placed, that was of 17, but on 15 itself, we had already filed a review application, and the Honorable Court was pleased to accept our review application, issue notice, and fix 5th of January. Lordship will kindly come to page 136. Heard so-and-so, so-and-so, so-and-so. The personnel department of Assam government preferred the connecting review application pertaining to judgment dated 1/6/2023 passed by a coordinate bench of this court consisting one of us, Honorable Mr. Justice Mitali Thakuria in WA 42/2023 with the present condonation petition for condoning delay of 165 days in preferring the review petition in the said judgment dated 1/6/2023. Actually, condonation is not required. As an abundant caution, we filed that also. Issue notice to the opposite party in both the condonation petition as well as connected review petition. So review was also, notice was issued. As J. Patore Learned Counsel accepted notice on behalf of the respondent number 1 in both the matters, no formal notice need to be issued to the said respondent. Notice need not be issued to pro forma respondent opposite parties at this stage. Both the condonation petition for delay in preparing the review petition as well as the connected review application shall be taken up for consideration of 5/1/2024. In the meanwhile, opposite party 1 may file reply objection, if any, in both the condonation petition as well as the review petition. At this stage, so-and-so Learned Advocate General, placing reliance in the decision of the Honorable Apex Court in the case of BCCI versus Netaji Cricket Club, reported in 2005-4 SCC 741, submitted that for subsequent findings, a review petition can be filed with regard to such decision of the court involving the issue of the case. He further submitted that after the impugned judgment dated 1/6/2023 in WA 42/23, during an inquiry process, it was found that the caste certificate issued to the opposite party was on the basis of fake certificate, that Golaghat Gaonbura certificate, which was never existed. Accordingly, the learned advocate general prays for stay of the impugned judgment dated 1/6/2023 passed in WA so and so. However, we consider the prayer for review petition with regard to the stay of impugned judgment and order dated 1/6/2023 passed in WA shall be taken up on the next date after filing of objection by the opposite party. In this situation, Lordship, my humble submission is that propriety demand, when a matter goes to the Supreme Court, when a notice is issued, this Honorable Court always takes the stand that as the matter is in session of the Supreme Court, the matter may be kept in abeyance. In that situation, Lordship, when we place everything on 18th, this was of 15th. Propriety demands that the matter should wait for some time. Let us wait till 6th of January. Heaven is not going to fall. So now the impugned order. But before going to the impugned order, let me place also, because a contempt will take place only when there is a willful and deliberate violation. So many judgments of the Supreme Courts are there. There was no hearing on this point at all. Very mechanical way this order was passed, but let us see what in our affidavit we have stated. Take chronological order. Page 61. This affidavit, additional affidavit which was placed along with the Chief Minister's note and all other developments. Page 61. And this was taken into consideration and the impugned order was passed on the basis of this additional affidavit. Here, although we sought unconditional apology, everything is fine, but this gentleman cannot comply the order straight away. He will have to take, if at all contempt has been committed, it is the Honorable Chief Minister, not anybody else. So paragraph 4, Lordship, I am giving the chronological order, how the things developed. On 24/11/2022, the Honorable High Court in 2286 has disposed of the writ petition by setting aside the impugned order dated 26/2/2021, passed by the state level scrutiny committee, by which the committee recommended cancellation of the OBC certificate of the petitioner. The Honorable Court has relied on the inquiry report dated 3/10/2022, 2019, made by the Inspector of Police CID while passing the judgment. That whole judgment, the whole opinion given by the inquiry report was the basis of giving the orders against the state, because that opinion was very wrong. Now it has come to knowledge. Everything has come to light. On 30/11/2022, Sri Monsoon Borkakoti has submitted a representation requesting concerned authorities to revoke her suspension order dated 12/3/2021 and to treat her period of suspension as the period in service. On 19/12/2022, the Personnel Department, against whom the contempt has been drawn, has sought a report from the Tribal Plains Department whether appeal is being filed against the Honorable High Court's order dated 24, and also reminders on the same to the department on 10/2/2023, directing for forthwith reinstate the petitioner. So he started the process. It is not that he is sitting over. On 14/2, the Personnel Department sought views from the Judicial Department on the above matter. On 17/2, the Honorable High Court has directed the Secretary Personnel Department to reinstate the petitioner in service forthwith in WPC and to consider representation of Monsoon Borkakoti so far as treating her suspension period as period in service, as the very edifice of the suspension order stood eroded in view of the Honorable Court's order dated 24/11/2022 in WPC 2286/2021 and the subsequent order of 8/28/12. 1st March. The legal remembers the Judicial Department has opined that the government respondents in WPC so-and-so and WPC so-and-so has not challenged the order in writ petition, as there was no reflect of the same in the records. In the event of WPC 2286 attaining finality on being not challenged, the order in WPC 682 of 2023 appears justified. The department to comply the order of reinstatement of Srimati Monsoon Borkakoti. On 9/3, the Secretary Personnel Department has moved the file for reinstatement of Monsoon. So he has done his part. He complied it on 9/3/2023. ALS before the competent authority, the Honorable Chief Minister, for approval of the same, which may kindly be referred to as note sheet so-and-so. So he started the process and he had sought the approval, which is the process as laid down in the Assam Rules of Executive Business of 1969. On 23 3/2023, the Honorable Chief Minister Assam has instructed to review the matter since findings of the CID and the state level scrutiny committee Jorhat are contradictory. Because before the committee, this girl went and said that my father is a general caste. And the police officer found the father is a coach from Golaghat. The Chief Minister has applied his mind here, Lordship. Our contrary, and LR has inter alia highlighted that the state respondent has not challenged the order of Honorable High Court. Thereafter, AG may be approached by the Personnel Department, Social Welfare to offer his advice on filing an appeal against the order of the High Court, by note dated so and so. On 7/4/2023, as per the instruction of the Honorable Chief Minister, the Principal Secretary Personnel Department has directed to take detailed opinion of AG, the highest officer. On 19/5, the AG opined that the judgment dated 22/2286 of 2021 and all subsequent orders required to be challenged before a larger bench by filing a writ appeal while explaining the issue of limitations by reasons. On 14/6, so Advocate General's opinion went on 19, then it was placed before the Chief Minister on 14/6. The Honorable Chief Minister has instructed Personnel Department to immediately file writ appeal as advised by the AG and to request AG to represent the state in the Honorable Guwahati High Court, which may kindly be referred. Now, the senior government's office prepared the appeal. In the meantime, they have come to know on 1st June, between 19/5 and 14/6, on 1st June, the appeal was already dismissed. When we are about to file the appeal, we have come to know the third party's appeal. So in that situation, my second opinion is that we should go and file SLP. Now, 16/6, accordingly, as instructed by the Honorable Chief Minister, records of the file so and so be sent to the office of the AG for filing the writ appeal before a larger bench and also representing the state government in the High Court. 3/12. Now, in the meantime, the Chief Minister also wanted an inquiry to find out who was at fault because two different opinions have come, one from the committee and one from the CI police officer, the vigilant officer, on whose basis all the cases the state government had to face the music. 3/12. The Learned Advocate General has opined that the state may either start a fresh inquiry regarding the verification of caste status of monsoon or to prefer a review before the Honorable Division Bench of Guwahati for review of the judgment of 1/6 in WA at placing the actual status of investigation report dated 3/10/2019. Also file an application for extension of time pertaining to the order dated 17/2/2023, by which the reinstatement order was passed. 4/12, accordingly, the records of the file so and so were again sent to the Office of Learned for above necessary action. 8/12, the Honorable Chief Minister has instructed Personnel Department notes it to initiate fresh inquiry by CID. 12/12, order of the High Court dated 7/12, contempt was received. In view of the order of the Honorable High Court, the file was again moved for reinstatement of the petitioner by Monsoon Borkakoti. So the officer against whom the contempt has been done, he again placed it before the Chief Minister for seeking approval for reinstatement. And thereafter, 17, the Honorable Chief Minister's note. In file numbers, thus competent or the Chief Minister has noted that authenticity of OBC of the petitioner Monsoon Borkakoti is in serious doubt, while fully respecting the majesty of the Honorable High Court and his commitment to comply with the direction of the Honorable Court, the competent has expressed that history will not forgive if the petitioner is that I have read. So all these explanations were given. Whether there is any deliberate attempt on our part to sit over or put the court's order to cold storage. When we see in black and white that a person is not OBC, and that fact was not properly placed before the Honorable Court because the subsequent inquiry made it clear that the officer, he was already a DP process has been initiated. So whether the Chief Minister himself is a Brahmin, he is an upper caste person. It is his duty, Lordship, under the Constitution. Even me is Lordship. So a post deserved by a backward class or the OBC category candidate, that person is deprived. And how? By manipulating all the officials who were at the helm of affairs in 2019. It is abundantly clear. Her statements, I have gone through the record. She herself stated before the Deputy Commissioner, before the inquiry committee. All these things are blatantly clear today. In that view of the matter, Lordship will kindly come to the impugned order now. (18/12/2023), page 189. This is under challenge. 139. Paragraph 2, 1, 2, 3, 4. These are narration. Now coming to paragraph 4. The respondent has filed affidavit in wherein it projected that the respondent has not been able to implement the order as the authorities have explored available remedy for filing SLP against the order dated so and so in WS. In fact, we have filed the review application. Already filed, notice was issued. It is also a stand of the highest law officer of the state has advised the department to prefer SLP before the Supreme Court against the judgment of so and so. This has no meaning. Having not satisfied with such explanation, this court under its order dated 7/12/2023 expressed prima facie view that the action on the part of the respondent is suggestive of contempt of this court order dated 17/2/2023. At this stage, D. Nath Learned senior government advocate representing the respondents prayed that he may be granted time till 13/12/2023 to obtain further instruction, and accordingly, the matter was adjourned and was fixed on 13/12/2023. While the matter was again taken on 13/12, similar arguments were advanced accordingly, having satisfaction that the contention raised in 13/12/2023 is nothing but a repetition of the statements made in the affidavit and arguments advanced on 7/12/2023. This court directed personal appearance of the respondent at 10:15 on 18/12/2023 so as to explain his conduct. When the matter was listed today, an additional affidavit was filed giving certain additional explanation. The explanation so given on oath revealed that on 1/3/2023, the LR Judicial Department has opined that order passed in so and so have attained finality. The department should comply with the order of reinstatement. The LR also was not at the knowledge that a third party's appeal is pending at that point of time, which was actually dismissed on 1/6/2023. Thereafter, the matter was placed before the different authorities, and finally an opinion of the so-and-so was sought. And the learned AG on 19/5/2023 advised to file writ appeal against the judgment of 2286. It is also seen from the affidavit of the AG has further opined that a fresh inquiry regarding verification of caste status of the petitioner should be initiated. The Honorable Chief Minister opined that this is repetition. If petitioner is reinstated in service without final verification of her OBC status, accordingly advised to seek 15 days time to take a decision either on implementation of the court's order or to file a review petition before the Honorable High Court or an SLP in the Supreme Court. So these are all noted by the Honorable Judge. A statement has been made that a review petition has been filed against the judgment dated 1/6/23 passed in so and so. The option of review suggested by the Honorable Chief has been opted. This court is of the considered opinion that history will not forgive the authorities in reinstating the petitioner in service cannot be a legal and valid ground not to implement an order of constitutional court. Beyond that, law is well settled that the court exercising contempt jurisdiction is primarily concerned with the question of contumacious conduct of the party which is alleged to have committed default in complying with the direction of the judgments or orders. It is equally well settled that when there is no ambiguity or indefiniteness in the order, it is for the concerned party to approach the higher court if, according to him, same is not legally tenable and such question has necessarily to be agitated before the higher court, inasmuch as the court exercising contempt cannot take upon itself the power to decide the original proceedings in a matter not dealt by the court passing judgment and order. Pausing here for a moment. Our option is to file review application or SLP. We have already adopted that process. Notice has been issued, fixing the date for 5th of January for consideration of the stay. We have already complied when all these things were noted. This is order of 18th. 15th itself, the things have moved. In the case in hand from pleadings and arguments shown by D. Nath, it is clear that the basic case of the response is that the order dated 24/12/20, whereby the order was recommended a state level committee dated 26/2 was set aside on the basis of inquiry report having no sanctity under law. The fact remains that even after having such an opinion, the state has not preferred an appeal till date against the order of 2612. And rather an appeal preferred by another respondent was dismissed by them. Now here, we cannot file an appeal against 2411 because this order was challenged in a writ appeal, which was dismissed on 1/6/2023. Against that, we have filed a review application. This order has merged with 1/6/2023 intra-court appeal. It has no meaning because the division bench also upheld the same thing. So we have filed a review against 1/6. This is primary, it's a manifest error on the part of the learned single judge in appreciating the facts here. Next page. The fact further remains that the judgment and order dated 17/2/2023 passed has remained unassailed till date. After the review application, we filed a review application against this order also. That is also listed today. Because the whole edifice, one edifice was the opinion of the vigilant officer in 2019. Now the second edifice for us is, Lordship, the second inquiry report. So all these things have come now. There are two diametrically opposite views regarding the certificate. That is why the Chief Minister said, give us 15 days, we'll come to a final conclusion and we'll place the whole report before this honorable court. We have nothing, we appointed her. It is not that we did not appoint her. We have nothing personal against any person. She was working for 2 years. Had we been anything personal or any mala fide intention, government would not have appointed her at the very first place. She was appointed, she was working, a third party complaint, APSC wrote to the state government that kindly verify her certificate, although we have recommended her name in OBC category. Government on the basis of APSC's document started the inquiry. And the inquiry officers and the committee found that her certificate is not genuine. She disclosed her actual facts. But the police officer went overboard and found her father, who is a general candidate, general person, Lordship, that her Gaon, the village Gaonbura from Golaghat issued a certificate that he belongs to Coast community. And when the second inquiry police officer verified it, then it was found that I have never issued that kind of document. The deputy commissioner's one fake letter was also issued. All these things have come to light, Lordship. And once all these are before us, we have to act. And what we are acting, it is legally permissible. Filing a review is a legal right of the state government or any party of the litigation. Why this review law has been developed? That Dhanani issues, after the BCCI's case, the Dhanani issues case, subsequent developments can always be considered to file a review. And that is why the Honorable Court was convinced. Therefore, notice was issued in the review application. Now coming to the next paragraph, Lordship. That being positioned, this court cannot traverse beyond the order dated 17/2/2023, non-compliance of which is alleged. Oh, sir. I'm sorry, paragraph 14, Lordship, I'm reading. The fact further remains that judgment dated 17/2/2023 passed in WPC has remained unassailed till today. No review has been filed seeking review of the order alleged to have been not complied. Though it is stated a review is filed seeking review against the judgment and order dated 1/6/2023 passed in the writ appeal 42, the order passed in WPC 2286 is not a subject matter either any review or appeal. Here, Lordship, my submission is that order passed in 2286 has merged with review order of 42/2023. This WA 42 is an offshoot of WPC 2286 of 2021. That being the position, this court cannot traverse beyond the order dated 17/2/2023 passed in so-and-so, non-compliance of which is alleged. By the aforesaid order, this court, without any ambiguity, directed the respondents to reinstate the petitioner forthwith, and existence of such an order was notified to the respondent on 30/11/2022. That is more than 1 year. In the meantime has been elapsed. It is again an incorrect findings because 30/11/22, the inquiry report was set aside. The direction for reinstatement was issued on 17th February 2023 in the subsequent writ petition filed by the same writ petitioner. So again, there's a manifest error here. That 30/11/22 order was for cancelling the opinion given by the state level inquiry committee. So this is not a case of elapse of 1 year now. In the meantime, has elapsed and respondent is taking a plea that such order has not been complied for the reasons that the OBC certificate issued to the petitioner is not sustainable, and therefore the order dated 24/11/22 passed in WPC is not sustainable. Accordingly, a review has been filed, is pending. This stand in the considered opinion cannot be said to be a case of non-willful or non-deliberate violation of this court order. The unconditional apology sought for, therefore, in the given facts of the case and in the backdrop of the conduct is rejected. Having the aforesaid satisfaction, the contempt is drawn against the respondent number for willfully and deliberately violating the order dated 17/2/2023 passed in so and so. Accordingly, the respondent is asked to show cause as to why punishment permissible under law shall not be awarded upon him for committing contempt of this court order dated 17/2/2023 passed in WPC 682/2023. As the petitioner is personally present and is being represented by his lawyer, no formal notice be issued by the returnable date. Respondents, if so advised, may file affidavit on the point of sentence. List on 21/12. So today the matter is fixed. So we have filed an affidavit and on top of that, Lordship, a opinion has been formed by the learned single judge. Against that, Lordship, this appeal is preferred under the provisions of Section 19 of the Contempt of Courts Act 1971. So the decision has already been taken that contempt has to be drawn. So therefore, so statutory right is there on the
See, against this 17/2/2023 order,
Lordship.
you have not filed any appeal, no review.
We have filed a review. It is listed
No,
today.
review is against that,
No, against 17/2 also review has been filed because 17/2's order, the whole edifice, if Lordship, I have the record here, the whole edifice is on the order passed in November last year. May I place that order? Then it will be very much clear. No, 115. पूरा select line to 16 or 7. Is 33.
yes. This is a final order.
Case number के नाम से दिया कहते हैं। अच्छा, review के नाम के नंबर से दिया।
Yes.
Lordship, page 33. 34 it starts 17/2/2023. Page 33. Now coming to paragraph 9, page 36. The writ petitioner's contention, Lordship. Three so and so, the learned senior counsel for the petitioner submitted that continuation of the suspension order dated 12/3/2021 is bad in law for two reasons. Firstly, the very edifice upon which the suspension order was passed is no longer in existence in view of the setting aside of the order dated 26/2/2021 by this court by the order dated 24/11/2022. And it was finally merged with 1/6. Further that the Deputy Commissioner also revoked the earlier cancellation certificate. So now their whole edifice is on that order. So now coming to the findings of the Honorable Court, what the Honorable Court relied, paragraph 16, page 40. Taking into consideration that the respondent authority, more particularly the appointing authority, still continues to place the petition under suspension in spite of the entire edifice of the impugned suspension order having disappeared because of that order. This court is of the opinion that the same constitute an abuse of the power for which the further continuance of the suspension of the petition is interfered with, and the direction is therefore issued to the appointing authority, the Secretary to the Government of Assam Personnel Department, to forthwith reinstate the petitioner. The government, however, shall be at liberty to post the petitioner as per the exigency of service. Now coming to paragraph 20. Considering the above, the respondents, more particularly the Secretary to the Government of Assam Personnel Aid Department, is directed to consider the representation insofar as treating the suspension period as the period in service in the backdrop of the above findings, whereby this court had categorically held that the very edifice of the suspension order stood eroded by the order dated 24/11/2022 in WPC so-and-so and subsequent order of so-and-so. So the whole basis is that order of 24/11. Against that, Lordship, we have filed a review because on the basis, these are all consequential action. If the base, the original order goes, the foundation goes, all subsequent orders will fall. If we are failing to justify our stand now in the review application, definitely, Lordship, we have other no option but to comply it, and which we are committing before this honorable court. Now everything is very clear, and now against this order of 17/2 also, the review application has been filed seeking some additional time, and which is review petition number 113 of 2023 in WPC 682. That is also listed today. We are not sitting idle, Lordship. For justice, for fair play, we are doing the best. And on 6th, if the learned division bench decides not to grant stay, then within half an hour we will reinstate. But our conscience will be clear. Ultimately, a message will go to the society. How a general candidate can be accommodated in a post reserved for OBC candidate. That is the core question. All these hyper technicalities, etc., will not be there before the society. And on top of that, I'm sorry. Yeah. On top of that, Lordship, what has Tanmoy Buragohai done, the individual contempt? 3 times he forwarded it to the Chief Minister for approval. At best, if anybody is creating a problem, it is the Honorable Chief Minister. Let him be a party. He will explain, he will file affidavit. But that is not the case. What my humble submission is, genuine person have to get the post. And we are bringing everything on record, Lordship. It is not that out of the air we are saying that the certificate is not correct or it's correct. The findings is very clear. The girl's own statement is very clear. In spite of that, Lordship, if when the things are before the on record, before the decision-making authority, is it not the right or not the duty who is constitutionally bound, who is on oath of the Constitution, to apply his mind and take a decision? What actually we are asking? our humble prayer is that let us wait till 5th of January, 15 days time. In the meantime, the ongoing inquiry is also completed, will be completed by maybe in 3-4 days time. And whoever genuinely gets, now one more aspect, what is her prayer? That she should be reinstated. She is getting full salary. We are not depriving anybody of livelihood.
How can she get full salary when she's under suspension?
Full 100. After a certain period, it is 100%.
No.
Okay, 75. Will 75%. It is not a case that will deny the 25%.
What is your problem if you can't, you can reinstate and proceed with the inquiry?
Yes. That is one way of looking at it. That is one way of looking at it. Had there been no findings by the subsequent inquiry, and when prima facie, it is clear, and she herself is saying, my father is a general candidate. And this officer, on the basis of 2 fake, ultimately, Lordship, the law is very clear that fraud vitiates everything. Fraud vitiates everything. Undeserving person, why he should be there for a single second? Will return everything if she is ultimately in the final end. Only 15 days time, not even 15 days. Now today is 21st. On 5th, the hearing will take place. And this Tonmoy Buraguhai, Lordship, he has not done anything. The contempt cannot be drawn against him. And from the various events that has taken place from March, there is no willful and deliberate violation. The Supreme Court has on this point, no argument had taken place. I'll place series of judgments on that. A contempt will be there when there is a willful and deliberate judgment, deliberate violation.
Why don't you reinstate her forthwith today itself?
We'll reinstate her on 5th.
Not on 5th, today.
Then
we'll stay the contempt proceeding.
No, contempt proceedings, Lordship, that is.
Then we'll stay the contempt proceeding.
If
You
that
can
be.
proceed with the inquiry. Nobody has stopped you. Just reinstate. After that, on the basis of inquiry, you can take.
Lordship, this is the arm twisting technique again, Lordship. I'm arguing on purely on law, Lordship.
No, that is the.
Purely on law, I am
what you
arguing.
said.
That could have been done 1 week ago also, Lordship. That could have been done. But why a general person take a post reserved for a backward class person?
Well, this is not correct statement. My learned friend has repeated this statement. Yes.
Till now, notice has not been issued.
No, my father.
I have the statement. I have the record, her own statement.
This appeal is not maintainable, my lord. Under section 19, an appeal lies only when there is an order of punishment. State is not properly advised. Kindly have this. Enough of time has been taken, my lord. Kindly see, my lord. This appeal
A stranger is arguing now. A stranger is arguing.
I am representing the party. Please come to para 11, my lord. The position emerging from this decision in regard to appeals against order in contempt proceeding may be summarized as thus. An appeal under section 19 is maintainable only against an order or decision of the High Court passed in exercise of the jurisdiction to punish for contempt. That is to say, an order imposing punishment for contempt. Neither an order declining to initiate proceeding for contempt, nor an order initiating proceeding for contempt, nor an order dropping proceeding for contempt, nor an order acquitting or exonerating the contemnor is applicable under section 19 of the Act. In special circumstances, they will be open to challenge under 136 of the Constitution. In a proceedings for contempt, High Court can decide whether any contempt of court has been committed, and if so, what should be the punishment and matters incidental thereto. In such a proceeding, it is not appropriate to adjudicate or decide any issue relating to the merits of the dispute. Half of the time, my learned friend was making submission on the merits of the case. This is not the forum. Go to Supreme Court. Any direction issued or decision made by the High Court on merit of a dispute between parties will not be in exercise of jurisdiction to punish for contempt.
and therefore not applicable under section 19 of the Contempt of Courts Act. Only exception is where such a direction or decision is incidental to or inextricably connected with the order punishing for contempt, in which an appeal under section 19 of the Act can also encompass the incidental or inextricably connected direction. If High Court for whatsoever reason decides an issuer makes a direction relating to merit of the dispute between the parties in a contempt proceeding, aggrieved person is not without remedy. Such an order is open to challenge in an intra-court appeal. If the order was of learned single judge and there is a provision for intra-court appeal, or by seeking a special leave to appeal under section 136 of the Constitution. So, my lord, the law is well settled. This appeal under section 19 is not maintainable under any circumstance.
Let
And
him
my
file an
lord-
affidavit to that.
Why
Let a
should I
notice
file
be
an
issued.
affidavit?
I'll argue on that. The decision of the court, what is left there? Is it-
Anyway, my lord, the
And one
other argument that, my lord, my father is, yes, my father is a general category. Even if my father is a general category, I can still be OBC if I am born and brought up in the custom of my mother, who is an OBC. And that is the judgment. And my lord, facts have not been told. My lord, going from here to there to there. My lord, why? How this is maintainable?
Lordship, do I have to learn arguments from him? I was arguing.
Like, yeah.
No, Lordship,
And,
he
my
is
lord,
saying that
my-
we go to, he is saying,
Yes.
go to Supreme Court. Do I need his advice? We know
Whatever
what
it
we
is,
have to
just
do.
like, yeah.
No, no,
He may be a great advocate, but state government is not seeking his advice at all.
Like, yeah, what we have said
Anyway,
before.
Anyway, my lord, my submission is,
Let it
this
be taken-
appeal is not,
Let it be taken up at 2 o'clock. Lordship. Let us try that review application before the learned single judge against 17-2.
no, my lord, my humble submission is, Lordship will not spend any time in this proceeding. This
Lord-
is not maintainable. Lordship will dismiss this appeal, my lord. Let them say whatever relief they want to say. But prima facie, it is not maintainable, my lord. There's nothing like it. I'm not trying to advise anybody. If somebody comes to me, of course, I'll advise.
He is giving
There
free
was a
advice.
time-
Free
There was a
advice.
time I advised Assam government for 8.5 years. That too with full authority. And my lord, history remembers everybody, my lord. And history will note everybody. That one need not worry about it.
Lotasil
Little-
feeling that's on the other side, not here.
No,
His
not
political statements will not help.
half of the,
The Lotasil field is just the other side of the road.
anyway, my lord.
So
This
I'll
proceeding-
definitely, Lordship, let me try
This-
this one more opportunity. Then if whatever Lordship said, we'll definitely obey. Whatever we are saying, Lordship,
You have two options. We'll give you a two. Otherwise, this
suppose
Section
Lordship,
nine-
Lordship, we are
Section
also
19
exploring 17-2s
is
also. Lord.
only on the best, only after final order is passed in the contempt proceedings. This is one aspect that you can keep in mind. If you are not successful in the review, bring the order of reinstatement, then we'll stay the contempt proceedings.
Sorry, I could not get Lordship.
If you are not successful in the review today, if you don't get a stay order,
Lordship.
bring the order of reinstatement of the petitioner, I mean the respondent, then we'll stay the contempt proceedings.
Lord.
You have two options.
No, take it. I fully agree. So we'll try before the learned single judge. Against
Otherwise, yes, it is, Mr. Chowdhury is correct. This is not maintainable.
there are two opinions on that, Lordship. I can argue.
That we can see,
Yes,
that we
Lord.
can consider later on. But we'll take up at 2, let's see what happens.
Yes, Lord.
But by 2, if you should have the order in hand, if there's no stay. You should have the order. You're the advocate general.
No, I am the advocate general, but I do not exercise that kind of discretions just to get the certified copy beforehand.
No,
I cannot-
not certified copy. The order of reinstatement.
Lord. Highly obliged.
Backwards. 5 minutes. That's fine.
My lord, these are minor variation, it does not matter. End of the day, it's a commercial transaction. Therefore, if a party is negligent, then he has to suffer it. Now, if your lordship will kindly come to page 58. on 3 count, my lord, the tender of the other bidder was, my lord, rejected. Now, this is part of the NIT, my lord. This is the first non-compliance. First subpara, court fee stamp of rupees 100 shall be pasted and cancelled on the format available on the website and then crossed, digitally signed and uploaded. So, my lord, this court fee stamp of 100 rupees is required to be first stamped, pasted, and then cancelled. And on format, my lord, after digitally signing, it has to be uploaded. This was not done by the other side, my lord. Then second, my lord, will kindly come to page 259. In fact, I should have referred to this page only. These are the 3 reasons, my lord, why the bid of the other side was, cancelled. Now, first para dealt with that. I have already dealt with it. My lord, please come to para 2. Whereas as per clause B1D6 of schedule 1, format for technical bid, the bidder is required to submit court fee of rupees 100 shall be pasted and cancelled on the format available on the website and then crossed, scanned, digitally signed and upload on the website. However, bidder Anjala Bosumatari, resident of Jyotinagar, Dhemaji, in contravention of the above clause of the bid document, has failed to comply with the clause and instead has submitted a document which is not legally signed and as per the requirement of the above clause. 3. Whereas as per clause D of the schedule 1 format of the technical bid, the bidder is required to submit an affidavit with the name of the mineral block for which the bid has been submitted. As there are many mineral blocks owned by the department, correct name of the mineral block is provided in the Schedule F information memorandum at serial number 1 of the NIT. The name of the MCA is required to be inserted in appropriate place of the affidavit submitted by the bidder. In respect of the above mentioned bidder, that is Anjala Bosumatari, it is seen that bidder has mentioned the name of the mineral block as cement quarry in affidavit dated so and so. So, my lord, name of the Mahal was also not properly, or rather wrong name was quoted. These are the 3 grounds in which the tender was, my lord, technical bid was rejected. Now, what had happened in this case, my lord? The forest department has outsourced this process to the Emtron. Now, it is Emtron who does all this, my lord. Now, before the learned single judge, before this single judge, my lord, before the single judge, my lord, these queries were posed. And therefore, my lord, the government advocate was asked to obtain the instruction. And this is what was given by the, my lord, Assam Emtron. Now, this is a communication by MD to the additional PCCF. With reference to the subject cited above, please find the responses to your query as follows. Affidavit was digitally signed or not? First page, my lord. No minor mineral due affidavit was not digitally signed. So it was not done. Whether court fee of 100 was submitted? Yes, court fee was submitted. Whether court fee was digitally signed? No, court fee was not digitally signed. Authenticated copy of the download of so-and-so an affidavit, authenticated copy of the said video is sent up to us, therefore, and attached here for a ready reference. So, my lord, these informations were given to the Emtron by Emtron to the forest department, which in turn was placed before the learned single judge. Now, learned single judge has construed these violations to be trivial, and therefore it will not vitiate, not entail disqualification or technical disqualification of the bidder. I'll respectfully submit, my lord, this is absolutely wrong. Please come to the learned single judge's order, my lord, at page 466. I'll place 2 judgments of the Supreme Court after this, my lord. 460. Huh?
66.
Uh,
68 about
70 to 20. It starts at 466, my lord. And my lord will kindly come to page 479. 29 জন লাগা আছে, Page 479, para 30 onwards. The aforesaid communications dated 7/8/21 and 26/8/21 would make it clear that re-verification exercise, even if it is presumed to be permissible under the law, was on aspect of certain complaint which were found to be without any basis. Under those circumstances, the aspect upon which impugn speaking order has been traded appears to be wholly outside the ambit of the complaint. In any event, the first reason cited is that court fee was not digitally signed by the petitioner. This court has already noted above that para 8 of both the writ petition contains a specific statement that all the documents submitted by the petitioners are valid. The aforesaid statement has not been denied in both the writ petitions. To the contrary, in WPC number so and so, an affidavit has been filed on 16/3/2022, and in paragraph 6 thereof, respondent authorities had stated that bid of the petitioner was found to be technically responsive. The allegation of not crossing the court fee has been specifically denied, and the copy of the court fee stamp submitted has been annexed as so and so in the affidavit in reply by the petitioner on 21/6/22, which should demonstrate that both crossed and digitally signed. Therefore, both the alleged grounds concerning clause 5 regarding eligibility and clause so and so do not appear to be correct. As regards the allegation of not writing the name of the mahal properly, this court has quoted that NIT in question dated so and so was concerned only one mahal, namely cement, sand and gravel mining concession area. There was no other mahal connected with the said NIT. The reason assigned is that name of the mahal has been written as cement quarry in an affidavit submitted along with the bid. That apart from the fact that the full name of the mahal has admittedly been written in all other documents, including the second affidavit submitted with the bid, such reason assigned not only appears to be wholly arbitrary, but also smacks of malafide intention on the part of the decision-making authority. In the opinion of the court, there cannot be any manner of doubt to come to the conclusion that the name mentioned by the petitioner cement quarry cannot mean any other mahal, but mahal in question, which was notified as cement, sand, and gravel mining concession area. The dictionary meaning of the term quarry is a place, typically a large deep pit, from which stone or other materials have been extracted. When name cement is clearly written only in one of the affidavit accompanied by the term, and view of all the contemporaneous documents, the rejection of the aforesaid issue is wholly unsustainable. Now, my lord, the authority has relied upon a particular clause, my lords. That clause is clause 13, which your lordships will get at page 123. End of the day, my lord, the recent trend or the view of the Honorable Supreme Court is, my lord, in such matters, the view of the employer should be given due deference. Rejection of bids. Page 123, my lord. Yes. Notwithstanding anything contained in the bidding document, the state government reserves the right to reject any bid or to annul the tender process and reject all bids at any time without any liability or obligation for such acceptance, rejection or annulment without assigning any reason thereof. Now, in which situation it can be done, please come to the third subpara. Without prejudice to generality of the foregoing, state government competent authority reserves the right to reject any bid or any criteria specified in the bidding document, including without limitation the following. Bids have not been submitted with all information details listed in the bidding document. Then D, my lord, bids have otherwise not been submitted in accordance with the bidding document. So, my lord, on account of these four, two, my lord, are attracted in this case. Therefore, the authority is absolutely right. Now, my lord, I'll just rely on one Supreme Court judgment. My lord, 2009, 11 SCC 9. Ase na? Any shone? 9? My lord, Lordship knows in the state of West Bengal versus Patel Engineering, Honorable Supreme Court had said, my lord, the best way to conform or avoid arbitrariness is to follow the tender conditions. Whether it is trivial, whether it is directive, whether mandatory, those concepts are, my lord, over a period of time, it stands diluted. Because other engineering has been almost, my lord, explained and distinguished in, my lord, judgment of Honorable Justice Madan Lakur in CCL's case, where it says, my lord, what on whether there is a compliance or not, unless one can allege mala fide, the judgment of the employer should be respected. That's the recent trend, my lord. In fact, my lord, in NJ Exports case, Supreme Court has went to the extent of saying that even if a legal point is made out, court should not intervene. Anyway, I am not making that extreme submission, my lord. Violation of Article 14 can always be examined. Now, in the judgment, my lord, well, I'm reading, I'll hand over the copy, my lord. Para 27, 2009, 11 SCC 9. Following the aforesaid legal principles laid down by this court, we are of the considered opinion that respondent one was negligent and was not sincere in submitting his pre-qualification documents within the time schedule laid down, despite the fact that he had information that there is a time schedule attached to the notice inviting tender. Despite being aware of the said stipulation, he did not submit the required documents within the stipulated date. Pre-qualification documents were received by respondent number 2 university only after the time schedule was over. The terms and conditions of tender as held by the Supreme Court are required to be adhered to strictly. And therefore, respondent number 2 university was justified in not opening the tender submitted by respondent number 1 on 1/12/2008, which was late by 3 days. According to us, no grievance could also be made out by the respondent 1, as the lapse was due to his own fault. My lord, this is a pre-existing document. The Honorable Supreme Court says nothing to it. So, my lord, when a tender condition prescribes certain condition, then you are bound to follow it. Now, my second limb of argument is, my lord, the petitioner's bid was defective. So, therefore, he was not an eligible bidder. Now, as held by the Honorable Supreme Court in Raunak, if a bidder himself is not eligible, how can he lay a challenge to the selection of somebody else? And which has been reiterated in Tata Motors case recently, my lord. Now, I put a copy here. Now, if your lordship would kindly come to page 34, para 8, my lord. Copy of the writ petition, my lord. That's the stand of the writ petitioner. Page 34. Page 34, my lord, on top. I'm reading the second sentence at page 34, my lord. The petitioner has submitted all the said documents required to be submitted with the tender papers duly digitally signed. As regards the ground number 3, your petitioner also states that same are typographical error and as such curable defect which ought to have been overlooked in the interest of the state because petitioner's bid is much more than the highest bid as appeared in the website. So he himself admits, my lord, his tender is defective. If your tender is defective, how can you lay a challenge to somebody else's selection? That is what the Supreme Court has said, my lord. Please come to, my lord, para 49 of the judgment. Para 49, my lord. The last 4 sentences towards the bottom. The High Court looked into the petition, has a lot. Para 49.
Yes.
The High Court looked into a petition filed by a party trying to assert its own right, as held by this court in Raunak, that a grant of judicial relief at the instance of a party which does not fulfill the requisite criteria is something which could be termed as misplaced. Since he himself admits that there is a shortcoming in his tender, that means he is not technically, he should not, ought not to have been technically qualified. So a judicial challenge at the instance of such a party is not maintainable. This was held in Raunak and this has been upheld. Now, end of the day, my lord, there is a settlement in my favor. There is no settlement in favor of the other side. Now, my lord, what was the enforceable right which the petitioner had when he approached the learned single judge? He had no, my lord, writ petition is for enforcement of right. It's not for creation of a right. Since your bid itself was, liable to be rejected, then you had no enforceable right. So at your instance, how can my, settlement can be challenged, my lord? I'm operating it, my lease is up to November 2026. Therefore, my lord, the learned single judge should have checked the records. Records clearly reveal what the authority has done. And Emtron has justified this by saying that these are the shortcomings in the tender of the writ petitioner. So merely because the writ petitioner in the affidavit in reply made certain averments denying the allegation, that is not enough, my lord. When record, it's a certiorari proceeding. In a certiorari proceeding, court must consult the record. Records will reveal whether what the authority is saying is right or wrong. So therefore, in my humble submission, my lord, Lordship will examine this matter, and since my lord, other side cannot suffer any prejudice, I will, supposing my writ appeal is allowed tomorrow. If I'm out of possession, my lord, it will create problem. I'm still in possession, my lord. So status quo. Huh? Oh, sorry. I'm sorry. Oh, sorry. There is a stay order. So since there is no, settlement order in favor of the other side, there cannot be any question of prejudice he suffering. So therefore, my lord, the order should be stayed pending disposal of the writ appeal. Tomorrow, supposing my writ appeal is allowed, if I am not given the benefit of the interim order, then my lord, I will be highly prejudiced.
What interim?
Stay of the judgment of the learned single judgment.
Okay.
So my lord, matter is very simple. Number one, he had no enforceable right. Number two, my lord, tender conditions are to be complied with, no matter whether, my lord, these are trivial or otherwise. My lord, I'm trying to test the argument or view of the learned single judge from another point of view. Supposing, my lord, this tender is invited for X mahal. A bidder submits a bid that he has quoted bid for Y mahal. Is the authority obliged to consider that tender, my lord? Semen query is not the mahal. Mahal's name is something more. So therefore, it can't be construed to be a directory or a trivial clause, my lord. It's a clause which has substance in it. Therefore, my lord, my humble submission is the learned single judge has, my lord, taken a very liberal view. And this ought not to be taken because it's a commercial transaction end of the day. In that view of the matter, I'll respectfully submit, my lord. Lordship will examine the matter. And during pendency, my lord, the order of the learned single judge should be stayed, my.
Made, please, your lord.
You're the caveat.
Yes, I'm the caveator, my
The
lord.
caveat. Heard
Caveat.
DJ Mandas, senior counsel for the caveat. Caveat stands discharged. Yeah.
My lord, actually, what my learned senior friend stated, my lord, entire background of the case has not been placed before your lordship. Your lordship kindly see there are two writ petitions. And my lord, your lordship kindly see there in pursuance to the NIT, dated, my lord, NIT that was floated in, my lord, 2020-21, my lord. In pursuance to the NIT, there are 9 bidders, my lord, submit their tender. 9 bidders. So then, my lord, tender evaluation committee evaluated the tender and found that 4 tenders are eligible for financial bid. Technical bid, they responded. There are 4 bidders, including me, my lord. In that point of time, my lord, one, my lord, student union of missing community, my lord, they file a complaint. This is a third party, my lord. Third party, my lord, on the basis of that complaint, my lord, what is the complaint, my lord? Complaint was that there is no
GST portal, GST certificate. The husband of the petitioners, my lord, has a criminal case in Arunachal Pradesh. So that also, my lord, nullified by the inquiry. But that is done behind my back. But in that context, my lord, they again reevaluated the tender condition, my lord. Reevaluated, my lord, and that financial, technical bid, my lord. So then passed the speaking order. That speaking order challenged before this honorable court. When speaking order was challenged before this honorable court, there is clear term, there is a stay order passed by this honorable court. That not to proceed with the, not to final decision, take final decision in the tender process. So that order was passed in presence of the government official, my lord, in the presence of the, my lord, Forest Department Council, my lord. After passing of that order, my lord, 1 month after, my lord, the final settlement order was passed. Then I again came before this honorable court challenging that, my lord. Challenging that final statement. That is why second writ petition, my lord. Now your lordship kindly see, in while passing, then, my lord, this honorable court, my lord, not only, my lord, state the order, final settlement order, direct the DFO concerned to make him party personally, and contempt notice was issued. So why contempt should not be initiated against you, in spite of the High Court order, stay order? Why you are passing that order of final settlement, my lord? Then order was stayed by this honorable court, and they appeared, my lord. He appeared. The DFO appeared with a record. Record was examined by the court. Many wrong thing has been, my lord, that place, my lord, where the record also speak, my lord. And then this honorable court, my lord, that honorable single judge, my lord, passed the order, asked them to make explanation before the court why you have, in spite of the High Court stay order, why you have passed a final stay order, final order of the settlement. He unable to, my lord, explain, and that's why, my lord, while disposing this petition, my lord, there is a direction to the registry to register a suo motu contempt against that DFO, my lord. Now, my lord, your lordship kindly see, my learned friend argued, my lord, there is a three condition they have, my lord, stated that I have not crossed the digital signature is not there. There is no, my lord, stamp paper is not been signed, my lord. And there is a difference in query. Instead of mining area, it is query. That everything is dealt by the learned single judge very clearly. I will place one by one, my lord. Your lordship kindly see, tender evaluation committee signed, my lord. They passed it. They have cleared my technical bid. Thereafter, my lord, how they can make a, my lord, another, my lord, inquiry, my lord, behind my back says that, my lord, my tender technical bid is defective. My lord, in clear term in both the petition, I made a statement that I have given a valid tender document, and that was admitted in our affidavit. Your lordship kindly see, my lord, page 324, my lord. Page 324, my lord, that is the affidavit filed by, my lord, DFO, my lord. Page, your lordship statement goes to page 327, para 6, my lord. Para 6, my lord. Page 327. Your lordship page para 6, my lord. May I read it, my lord? The total number of 9 numbers of bidder were received against the e-auction notice aforesaid. The bid process consists 2 stages, technical and financial bid. The petitioner also afforded her bid among the aforesaid 9 bids. The technical bids so received were duly evaluated, and 4 numbers of were found technically responsive, wherein the petitioner was also included. Where that para, my lord. So your lordship kindly see, that is on oath, my lord. They have stated in the affidavit that my technical bid is responsive, my lord. Your lordship kindly see, this para, my lord, they have swearing from record. That means after gone through the record, they filed this affidavit, my lord. And that is, my lord, supported by the tender evaluation committee report, my lord. in the tender evaluation committee report, my lord, in the CS, my lord, comparative statement, it is clearly mentioned, that is, my lord, my technical bid is approved. Now, this is one affidavit. Now, another affidavit, your lordship kindly see, that is in another case, my lord, that the page 358, my lord. Page 358, my lord. Annexer, sorry, my lord. Page 50, clause B, my lord. The total number of nine bidder were received against the EA vehicle notice stated that the bid process consists of three bids. Technical and financial bid. The petitioner also offered her bid among the 9 bidders. The technical bid of the receipt were duly evaluated and 4 numbers were found to be technically rational, where the petitioner also included. So in both the affidavit, they have admitted my technical bid is found to be eligible for technically response. That is also swearing from their record. Now, my lord, just to my lord, given the benefit to the, your lordship kindly see most important fact, my lord. My bid is, my lord, 3 crores 21 lakhs. And the person who was my lord, allotted, the private respondent, my lord, who is the appellant before your lordship, his bid is, my lord, 1 crore 6 lakhs. His difference is more than 2 crores, my lord. So your lordship kindly see, that is why, my lord, the public interest is involved in this case, my lord. My technical bid is, my lord, evaluated by technical evaluation committee, and it was found valid. Thereafter, my lord, just to, my lord, giving benefit to the private respondent, my lord, they again that speaking order has been passed. That which cannot, that has been done behind my back. All these questions, my lord, clearly, my lord, clearly executed by the learned trial judge, learned single judge, my lord. And not only that, my lord, there's a para, your lordship kindly see, page para 26 of the judgment, my lord. Para 26 of the judgment, my lord. Para 26, my lord, page 477, my lord. In a very clear terms, your lordship kindly see, having held that there is a jurisdictional error in issuing the impugn order dated 3/2/2021. That means, my lord, settlement order. So this court may not be required to go to the other aspect of the challenge. The view of the development which taken place during the pendency of this petition, which established his recast is filing the second petition, WPC number 1609/2022, it will be necessary to deal with those aspects. The court is reminder that there is a specific order, this proceeding pass in court, this court directing the DFO Dhemaji to show cause as to why action under the Contempt of Court Act 1971 should not be taken against him. Your lordship kindly see, while, my lord, this stay order operating from this honorable court, there is a order passed by this honorable court in presence of both the parties, my lord. And while operating, then how he can issue a, my lord, final settlement order? On that point ground alone, my lord, this petition is allowed to be deserved to be allowed. So all these things are, my lord, taken into consideration by the learned single judge, my lord. So my humble submission for your lordship, my lord, there is nothing to interfere, my lord. It is a very sound order. Your lordship kindly see this tender, this type of, my lord, tender process, my lord, when court can interfere. Very clear terms, all the judgment passed by honorable apex court, my lord. When there is a public interest is involved, when there is a arbitrariness and malafide is there, then the court can interfere, my lord. And that aspect of the matter, my lord, learned single judge, my lord, pass this judgment, my lord, there is nothing to interfere by court. That is my submission, my lord. And from very beginning, my lord, there is a stay order. He has not, till now, he has not been allowed to appoint, my lord.
My lord, 2 minutes reply, my lord. My learned friend has referred to page 322, my lord. Please come to page 323. Oh, 322 to 21. 327. Huh? 327. Oh, 327. I'm sorry, my lord. 328. My learned friend referred to para 6 at 327. এই পেজ বিলাক বৰ জাতাকে লিখে। এই My lord will kindly come to page 328. My learned friend should have brought this also to your lordship's notice, that in view of the above, after submission of the aforesaid status report, the deponent thoroughly examined the documents submitted by bidders who has succeeded in the technical stage and found certain anomalies in the bid documents submitted by the petitioner and advised rejection of bid of the petitioner, and also prepared a draft speaking order and forwarded the same to the higher authorities, height letter dated 1/9/21. And the higher authorities, after examination of the matter, endorsed the advice of the deponent. So this is also shown in as a matter of record. So my lord, clause 13, that's the bid rejection criteria. After everything at the last stage also, my lord, this, power can be invoked. And it was done. And my learned friend has not made any submission on the 3 non-conforming.
Yes, my lord, I have already made my submission. Again, my lord, if you are required, I'll submit my submission. I'll make my submission, my lord.
No.
Once, my lord, they stated in announced that, my lord.
So therefore, my humble submission is, my lord, lordship will examine the matter and pass an appropriate interim order.
Who appears?
We are contemplating appeal under Title 46 law. So, and I am endorsing the view of my understanding authority. So, contempt is a component of that order. As a appeal authority, using a magnifying glass, and after a cycle, now this whole tender was hanged in limbo because my lord, 4 financial bids were there, successive for the financial bids. My lord, now many months time has elapsed, the other 2 successive bidders, they have withdrawn the earnest money. We don't understand. Election is proceed for the financial bid. So now whether the order that is also, how can we proceed? And those paragraphs that they're relying on those similar, that same paragraph it justifies why we have to go for that and re-evaluate.
Take over. Standing council, forest, and environment. Environment and forest. Appears for respondents 1, 2, 3, 4. And Mr. T.J. Mahata, that is by Mr.
J. Sharma. J. Sharma, my lord.
The council appears for the you want to take 6 or
Fixed date, my lord. No,
when do you want? January?
before 18, my lord.
Not here.
11 January.
It will be after 18. Already, my lord, lots of case fixing before. Immediately after Bihu, it will be problem, my lord. In the first week of February, my lord.
6. The next but
Item 18. My lord, 6th, I have some difficulty, my lord. Let it be after 8th, my lord.
item.
Not 6th,
Oh,
not on 6th, my lord. Maybe 10th or something like that.
10th is Sunday.
Lordship can have it on, my lord, 12th.
Okay.
Diploma. Item 18.
May it please your lordship. Well, this intra-court appeal is against the rejection of a prayer, interim prayer, to consider our price bid. What happened when the irrigation department, they issued an e-auction notice for implementation of certain projects against 5 packages. And I participated in the tender process against all those 5 packages. Then on 30th of November, we were communicated by text message that our bid was rejected during technical evaluation
by the evaluation committee. But no reason was assigned to us. So we approached the department to know the reason, but they were very tightly matter. Nothing came. So we filed a writ petition. In the writ petition, the government council on instruction is stated that the reason for rejection of the bid is that presently I'm serving as a Mojada. So that is the only reason which has rendered me ineligible, because I'm serving as a Mojada. My lord, my respectful submission is that but there is no legal impediment for a Mojada to carry on trade or business. It is a settled legal proposition, my lord. This proposition has been settled long back in Kanak Chandra Datta. Kanak Datta, my lord, very well aware, but still, my lord, I just want to place one paragraph from Ekon Divoni. Kanak Datta, my lord. Para 8. Technically, say para 8. Para 8, my lord. A Mojadar may own a tea garden or other landed property and engage in trade or politics. But if any of his extraneous occupation interferes seriously with his primary duties as a Mojadar, the deputy commissioner is required to consider whether he should be retained in his office. So there is no difficulty for a Mojadar to carry on trade of business. He has this right to carry on trade subject to a rider. That his trade of business should not interfere and interfere seriously with his primary duties. Now here it appears, my lord, from this judgment of the order of the Honorable Single Judge, he is harboring the notion perhaps that if this tender is given to me, to settle with me, it will hamper my primary duty as Mojadar. Page 51, your lordship will find, because para 8 was noticed, but perhaps my respectful submission, this is, well, jumping the gun. It is not for the province of this court to decide it. It is the duty of a deputy commissioner, who is the appointing authority, to decide it, whether that will interfere or not. There must be some complaint against me, and then the deputy commissioner will take a call. It's not for this court to decide that. He's basically prejudging it, man. That will perhaps interfere with my primary duty. So his first ground, perhaps, my lord, is wrong, because Kanak Datta says, I have the right. But as a bidder, my lord, only right I have is the right to equality and fair treatment. Their action must answer the test of Article 14. The question is whether I have been unfairly treated. So I am only saying that you consider my price bid. There is no difficulty, should not be any difficulty to consider my price.
Is over.
Lost.
It is finalized.
Well, inform that work order has been issued very recently. Our instruction is that work has not started.
What the
Yes,
single judge.
I've seen that.
Lordship, may I place the instruction that I received in the petition?
May I get it? Okay, sir.
Furnish the copy.
Lordship, I'll furnish it.
Lordship, may kindly see when this work order was issued. One was issued on 12/12. One was issued on 11/12. One is issued on 8/12. The work is yet to be started, man. There are 5 packages.
All packages lordship order has been issued.
Last one issued on 12/12.
Your writ petition was with regard to
This, my lord,
non-consideration
of my bid, my lord,
right.
for illegal
The
rejection,
process is over, work order has been issued.
my lord.
Now you have to challenge the work order.
The lordship in the third party right is also arises.
No.
Lord.
My lord, we try to find out, my lord, figure out this particulars of these successful bidders, but they are not, my lord, willing to offer this information to us.
This is lordship, of course.
I mean, without that, my lord, no, we need
No. As per
this
the
brief.
instruction,
I will definitely help my friend.
all work
Lordship.
orders have been issued. Now, practically, the first writ petition, which is now pending,
Lordship.
that has become
I appreciate that.
that
I appreciate
becomes
that.
instructed.
My lord, when we approached the court, my lord, work order is not issued there. After that, the work order we issued. My lord, we are only saying that you please consider my price bid. If my price bid is higher, my lord, the matter ends there.
No, that's why, apart from that, apart from the grounds that you have taken, the writ, now a third party right has come in.
Yes, I agree.
Now you have to challenge the work order, impeach him as a party. Thereafter proceed. Now this actually this with the appeal is
Infractions.
infractions.
Lordship.
There's nothing to consider in this appeal.
I appreciate that. I appreciate that.
So you,
I concede
we
that.
can allow you to withdraw it with liberty to approach the appropriate forum and then close the matter instead of dismiss.
My lord, my writ petition is still pending, my lord.
Yeah,
There,
that's why.
of course, my lord, I can amend it by making
Mr.
and nothing.
And that's
And nothing.
with liberty up then Upadhyay, then Standing Council,
Irrigation.
Irrigation, Standing Council, and with liberty and
Obliged. Obliged.
19. Item 19.
Here we are yet to file our affidavits, the finance department and the education department, for which time we will be. They've challenged the rule, the revision of pay rules, my lord.
A date may be given on the last
Chief
assessment.
Procurer and Council for the Petitioner. Mr. R. Majumdar, Learned Standing Council, School Education.
School education.
And Mr. Nayak, you have filed your affidavit.
I it is pending, Lord. I'm praying for some more
And
time.
Mr. P. Nayak, Learned Standing Council, Finance Department. Praise for how much time?
I'll need 4 weeks.
4 weeks time to file your respective praise for it's taken on. It's what? 29.
Obliged. I'm obliged.
Item 8 for orders.
So the repetitioners here are praying for implementation of the 2006 Act, by which we were required to register and recognize all the elementary and secondary schools under the RT. That particular Act of 2006 is under challenge in another repetition, that is 2806 of 2012, where a status quo order was granted. The last order of this Honorable Court, my lord, would reflect in this repetition. It is to be listed after those cases are disposed of. Unfortunately, my lord, it was then heard by the then Chief Justice, my lord, but he left.
before the judgment could be delivered. So perhaps a rehearing will now take place. If that act is set aside, my lord, the registration part under the act cannot come into play. This will become an infractuous act. And if that petition, the government succeeds in defending it, then my lord, we are ready to, in any case, register and because of the status quo, we are not being able.
Your good name, please.
Debarghar Roy, petition in person for petition number 3.
Mr.
Debarghar Roy.
Roy. On request made by our Nothing council.
School education, madam.
But again, on when?
That those matters are fixed on 23rd of January, if I'm not wrong. Yes, 23rd January, some day after that.
Then we list in February.
February.
After 15 February, Lordship.
21st.
Much obliged.
I'm obliged.
Item 9.
My lord, in this case, I am praying adjournment for today, my lord. I have to take instruction from my client whether order has been complied or not.
Lordship, it has already been complied and affidavit has been also been filed to that effect.
What more do you want?
Then, my lord, your lordship may close this proceeding with given liberty, my lord.
What liberty?
If
Everything has been paid, Lordship. Lordship is your affidavit with
Where's
the
the
page number 56, Lordship.
Page number?
56, Lordship, filed by respondent number 4.
Where's the order? Compliance?
Lordship, nothing is remain here. We have already made all the area payments, Lordship. Page
Have you got
number
all the payments?
15.
my lord, that I have not instructed, my lord. That one date may be given, my lord, for the short date.
Okay. On request made by Mr.
K. Kolita.
K. Kalita. This after
First week of January, my lord.
this matter again on.
Obliged, my lord.
Certainly no adjournment.
Yes, my lord.
Item 10.
May it please your lordship. Lordship, in terms of this honorable court order, my lord, still we have taken on 4 and 5, my lord, they have appeared. And we have filed a stay pending petition, my lord. Against this stay pending petition, yesterday they filed an objection. My only fear is that, my lord, matter may be taken up on 4th of January, my lord.
Okay, heard Mr. P. Cycle, council to be up. Who appears 4 and 5?
I'm for respondent number 4 and 5, Lordship.
Mr.
MS Mondal.
MS Mondal, councillor being for respondent 4 and 5. That they file objection. When?
The objection filed by the, my lord.
By the appellant.
Appellant,
Okay,
not
okay. Appears to the response 4 and 5. Mr. You have filed your objection.
Yes, we have already filed yesterday.
When?
Yesterday, today I have filed. Today.
Mr. N. Sharma, the response. Appearing for response of the public
Uh,
service
appellant.
petition. Submit that they have filed objection. On
Today.
today,
Yes,
that they are filing objection in the court. When?
4th of January.
4th January.
11.
Please, in this matter, I've seen that the respondent number 10 in the writ appeal, that's a competent authority for land acquisition, has not been made a party in the IA, my lord. It's my lord, it's imperative that they be made parties because the NHIDCL, they are requesting for the copy of the my lord, the valuation report submitted by the CPWD pursuant to directions of this honorable court. My lord, this report has to be produced before the arbitrator. And the competent authority is a person who might dispute it later. So if he is not made a party in this present proceeding, my lord, it might create problems later on.
There's nobody appearing.
अपनी CPWD union. On the last date, my lord, I've been informed, my lord, that the CPWD was directed to be present, my lord. Notice was served. The deputy SGI was representing. Uh, My lord, for the last occasion, CPWD was served copy. And my lords, I hold a report, which was, my lord, the joint verification was conducted. And my lord, these parties are.
Here, Mr. Nair is saying that you require to, one party is necessary.
That is, my lord, a different aspect of the matter, because, my lord, I am here before the court of modification of order, where, my lord, I am agreed by inaction of the CPWD. These are, my lord, peripheral with whom CPWD takes it up. That's not our issue, my lord, because we are not the authority who can provide that. This is something coming up, my lord. I can implement them. There's no issue. But, my lord, as I have pointed out,
You just implement it instead of wasting time.
I can implement it, my lord. There's Karbi Anglong, my lord, joint secretary to the revenue Karbi Anglong. Apart from
They have
that,
a standing council as well, my
yes, my lord. I have handed over on 19th, my lord. That was signed by them, my lord. That is the joint exercise.
D.
D. Gogoi, my lord.
You are for the,
I am for the appellants, my lord.
not for the applicant.
Applicant.
Praise for some time to file in IA for impeachment of the praise follow. When do you want?
Immediately on opening, my lord.
List on 9th.
5th, my lords. I can.
Many cases are fixed.
My lord.
Item 12,
CPWD may be given reminder, my lords. They have. Accept. My lord, their name may be reflected, my lord. CPWD. Oblige, my lord.
Item 12.
What is this?
Maybe your lordship.
Yes.
My lord, in this case, my lord, there is a IA, my lord. The issue is that, my lord,
What is the IA for?
my lord, for condoning a delay of 46 days.
Who appears for the?
My lord, the state has filed a appeal, my lord.
Oh.
In this case, my lord, the issue is very simple, my lord. My lord, for the government employee, my lord, there is a scheme. The person who dies in harness, my there is a
I'm
complex,
not on the scheme.
my lord.
I'm on the delay.
My lord, my lord, 46 days, my lord. Notice has to go, my lord.
But Mr.
SP does, my lord.
SP does counsel for the applicant. Mr. N. does.
Performer number 2, my lord.
And employment and craftsman training. MS, you
Final respondent number 2, T. Bormon, on behalf of RK Talukdar.
no.
Number 2.
2 নহব 3 হ'ব একাউণ্ট জেনেৰেল হ'ব এইটো 2 হৈছে চিফ সেক্ৰেটাৰী এমএলএ
Oh, opposite party.
But the state has filed a appeal, my lord.
You have to serve copy on the opposite party.
Yes, my lord.
Okay. Issue notice. MS, Mr. Endas and Governor
respond number 2 my lord
and you are for Accountant General. And MS.
Hello 2,
Your name, please.
T. Bormon,
T. Barmer, Senate Council,
behalf of RK Talukdar.
Mr. R.K. Talukdar, Senate Council, the applicant to take steps for purpose of notice of the opposite party of one by the report. This after 4 weeks.
item 13
Oblige,
Yes, what is this?
Lordships, we have filed an IA for condonation of delay of 169 days in preferring the writ appeal against common judgment and order dated 31/23. Lordship, similar order is at page 14 of the IA. Lordship, notice may go to respond number 1 and
MS?
U. Sharma,
U. Sharma, Leonard,
Junior Government Advocate.
Junior Governor for the applicant. Issue
Uh,
notice.
Dusty service may be allowed, Lordship, on respond number 1.
Who appears for 2, 3, 4, 5?
These are components of the state government, Lordship.
If you notice, applicant to take the photo of the part of what
By Dusty,
I
Lordship.
registered for the report. But additionally, the applicants are also photo of the part by Dusty service within a period of 2 weeks.
Lordship.
After applicant the 7th after 4 weeks.
Much obliged, Lord.
Item 20 from supplementary list.
My lord, in this,
My lord, I had two, my lord. Along with item 16, my lord, Mr. Sekia will appear in this case also. Can we take, minor correction is there, my lord, only.
my lord, this copy has not been served. My lord, notice has to be issued because an IA for correction of order. My lord, this order was heard by hearing both the parties. Now they are coming and saying there's a correction of order. So my lord, a notice has to be issued because I'm a respondent number
My
1
lord,
here.
may I submit, my lord? Lord, may I take it at 2, my lord, along with item 16. He will be there. Short, my lord. Lordship.
Item 21.
My lord, this case relates to the, my lord, condemnation, my
There's
lord.
a IA, my lord. For delay of condemnation, will file objections.
My lord, let them file, my lord, no problem. Matter relates to the, my lord, eviction, my lord. I projected a case, my lord, on the government land, my lord. Forest department is pretending as if it's a government land.
Whatever it is, we can't get into the merit.
My lord, only, my lord, since, my lord, it
How
is
many days delay?
only 52, my lord.
No, my lord, because what has happened, my lord, this is a consent order was passed. Read petition, runner single judge has also observed that they are in occupation Sarkari / forest lands. They have agreed to, my lord, vacate. Now they have come.
My lord,
And they have also moved on read petition, my lord, challenging this order.
Okay, heard. Yeah,
my lord, only short date may be given, my lord, is the eviction matter, my lord, all the department are
The applicant. Mr.
D. Gogoi,
Standing counsel.
For the forest.
Forest.
Environment.
Forest and Environment Department. Place for 2 weeks time.
2 weeks.
My lord, can it be, my lord, short date, my lord, because it's the eviction matter, my lord, lordship fix the date on 5th, my lord. If it is this.
He's having a holiday also.
Yes, my lord. Just now, my lord, I was asking for the date more urgent issue.
Let him have his holiday also.
Lordship, can it be on 8th, my lord?
Place for week time. Of the place. It's on 9.
Nice.
That will be.
Hold it.
My lord, item number 14, my lord. The date may be weeks, my lord.
Item.
Item number 14, my lord, hearing matter, my lord.
Okay, you are appearing for?
Appellant, my lord. My lord, on 9th or January, my lord, or 16th. M. Dutta, my lord.
M. Dutta, learned counsel for appellant. It's on 11.
Obliged.
You are pronouncing only a judgment, isn't it? At 2. Then I'll wait for you. Oh, what I can do, we are also pronouncing some judgment. I pronounce it. Yes, yes. I think that would be it.
हाँ तो ये हमारा
बोल आया है In that matter, that's it.
In this case, the matter is very faint chance of reaching. Item 9, 6 and 7 are going on till 1 o'clock. So what I am praying, Lordship, that let the issue regarding maintainably be framed and fix it on the reopening. I'm not praying for any stay order. Nothing. And let them file also the power and everything so that they can also formally
Okay.
on maybe 6.
But Mr. D. Cycle and a senior counsel, Leonard Advocate General, assisted by Mr. D. Nutt, Leonard Senior Government Advocate for the appeal. Stop. Will issue notice?
Yes.
Or no,
My lord, notice should not, cannot be issued.
Not notice.
In my humble submission, my lord, appeal is not
On the
maintainable.
point of maintainable notice
On
may
the
be issued.
issue of maintainability.
Maintainability. Let it be on 4th or 5th,
Also
Lordship.
heard Mr. K.N. Chowdhury, Leonard Senior Counsel, assisted by Mr. J. Patawari, Leonard Counsel for the opposite part, respondent, sole respondent. Stop. The issue of maintainability of the present contempt appeal shall be heard on when?
Let it be on 4th, Lord. It's a Thursday.
4th January 2020. Please take out.
Highly obliged. Keep you. In this case, Lordship, I am praying for, in my our opinion, Lordship, there may be a slight typographical error. If Lordship is pleased to look at the order, this is for correction, this petition has been filed. At page 26.
Of the IA?
Yes, of the IA. So we filed on behalf of Rajeshwari. Rajeshwari Swaran Sankaran filed the writ appeal. And on that day, after hearing the Lordship, instead of staying the impugned order passed by the learned single judge, was pleased to protect our interest by saying in the last line at page 28, position of respondent number 1 shall not be disturbed. In fact, position of appellant, it could, because I am working there for last 1.5 years. Respondent number 1 is who is seeking appointment.
Oh, yes. Something went wrong.
Yes, that's the type.
Heard Mr. D. Cycle, Leonard. You are appearing as
a senior counsel.
Leonard Senior Counsel, assisted by Mr. B. Gogoi, Leonard Counsel for the applicant. By this,
Central government is
also heard MS.
You, Sharma. I'm appearing for respond number 1 in the present.
MS, U. Sharma.
Not.
For the respondent number.
1.
And Mr. K. Gogoi, Leonard CGC, for the respond number. 2 to 5. You are the CGC? Stop. Para. By this application, the applicant is praying for correction of the order dated 15 12/2023 passed by this court in writ appeal number 5458 of 2023 and IA within bracket civil number 3745 of 2023. Insofar as the interim order is concerned, stop. The learned senior counsel for the applicant submits that in the order it should read as appellant and not as respondent number 1. Stop. On consideration of the materials on record, we find that some typographical error has crept into this order dated 15/12/2023, and accordingly, the error is rectified by modifying the order dated 15/12/2023, and the interim order shall read as under, within inverted commas, till the next returnable date, comma, position of the appellant shall not be disturbed. So, with the above observations, I is disposed to.
Highly obliged.
Any more?
Products on this item 1.
Yes.
With zero. My lord, the responding corporation quoted a tender, my lord, which you'll also find page 88. That was on, my lord, 16/8/2022. Page 88, my lord. Now, in this tender, my lord, the supply, it was there. And there was a condition, my lord, that the class 1, my lord, the bidders, that means who can supply more than 50% of the local content, local products, will be given the preference. My lord, I give a certificate that my local content will be 82%. Accordingly, my lord, by giving the preference, my lord, the letter of acceptance was issued, and you'll also find the letter of acceptance at page my lord, letter of acceptance at page 252.
Yes.
You'll also find that on the right hand side on 52, the total value was 15 crores something. As you also got it. Now, although the letter of acceptance was for 15 crores, the purchase order, which was issued to the petitioner at page 267, this one is one. 267. Well, the purchase order was issued only for a sum of rupees, my lord, 12 crores.
Where is that?
Well, the amount was not mentioned, but the quantity is mentioned. I also find the page 266, and the quantity is mentioned. I've given that in the paragraph that what is the value of this one. That is at page, my lord, I mentioned that one, the value. That is near about 12 crores, and that is not disputed. I will show to your lordship, my lord, in the subsequent admitted that 12 crores. Now, after this purchase order was issued, my lord, the release order was issued to me, and that was only for 5 crores something, which you'll also find at page 318. Below the quantity is mentioned, and the amount is 5 crores 50 lakhs 50,300. That is also admitted. There is no dispute about that. although the, my lord, the purchase order was for 12 crores, the bid was for 15 crores, the dispatch order was only for 5 crores something. Now, after that, my lord, I supplied for goods for 4 crores 50 lakhs. Thereafter, the supplies were stopped on the ground that the 82% which I've shown, that was not 82%, but 52%. Ultimately, my lord, I requested that why the other quantities should not be supplied. They have not supplied, they stopped it. Thereafter, a so-called notice was issued to me for blacklisting. I submitted reply, and the blacklisting order was on the ground that you were shown 82% earlier and now 52%. That is one ground. Secondly, that I submitted that I will supply the order which is as per the purchase order. 12 crores something I am ready to supply. I gave a reply. In the reply, the 52% they have accepted. They have not gone into it. Now, Your Lordship, I will show to you, Lordship, how the so-called notice has been dealt with. Your Lordship, just see the so-called notice. The so-called notice you will also find at page 375. And I will take Your Lordship to page 376. Because we are concerned with the supply only, because they have that one, the first part they have accepted. You'll also may see page 376. The last 3 lines. You have, as you also got it, you have further mentioned that on the basis of the available raw materials to meet the stipulated local content requirement for a class 1 local bidder, you shall only be able to cater the first call PO quantity for the BPCL. So, I said
No,
that
you are
the
reading from which?
page 376,
Oh,
first paragraph, the last 3 lines.
okay.
You have further mentioned that on the basis of the availability materials to meet the stipulated local content requirement for a class 1 local supplier, you shall be able to cater to the first call of PO quantity to the BPCL. So I submitted the purchase order which was there, that was for 12 crores. I will supply that one because 15 crores you have not issued the purchase order to me also. That is for 2022. 1 year has passed, they have not issued the purchase order. I submitted that one. I gave a reply that I was ready to supply the purchase order, that is 12 crores. Now we'll also see the order which has been passed at page 408. The last but one paragraph, May I read, my lord? View above, it is noted that against the fulfilling of the contractual obligation of supplying of 12 crores, they are saying contractual obligation of 12 crores. Worth of MECB so-and-so against the contract so-and-so confirmed, implied that they will be not be able to supply worth of maybe 3 crores something against the contract, which works out to be 24%. So where I've said, I've never said. I have said that I will supply up to 12 crores. In fact, my lord, I will submit to your lordship a mail wherein I submitted that kindly allow me to supply at page 405. Page 405, my lordship, can you see? 405, my lord. A letter which was sent on 12/9/2023. My lord, a chart I've given. Total LOA quantity, first call PO, that is 37,000, that is 12 crores. Now, inspection and all those things, and I've said, further, we are yet to raise the intimation call for balance quantity of the PO1. Please refer to column number so-and-so. So we requested that kindly issue me the release order for the balance quantity. And now they are saying that I have said that I will not be able to supply 12 crores. I've never said. I've specifically stated they are not issuing me the purchase release orders. And they are not releasing the release orders, and they are saying that you have committed breach of contract. They have released order only 5 crores and they have accepted 4.50 crores only. And 1 year has passed. The purchase order was for 12 crores only. And the 12 crores, I said, kindly issue me the release orders for supplying the balance quantity of 12 crores. And they are mentioning that I have stated that I will not be able to supply the 12 crores, and it works out to 24%, so blacklisted. It is absolutely, my lord, the arbitrary, and only it goes beyond the so-called notice. Your lordship is aware of the various judgments of the apex court, my lord. I may just show. You give a so-called notice for something else. You pass a order, something which is contrary to the records. Well, lordship may see page 6. And the relevant part, my lord, page 15. Paragraph 18, my lord.
Yes.
My lord. This court in so-and-so has described the blacklisting as being equivalent to a civil death of a person because blacklisting is negative in nature and debars a person from participating in the government tenders, thereby precluding this person award of the government contracts. It has been held as under, I may skip over, my lord, whatever I think. I may read 2-3 lines, my lord. It is a common case for the party that the blacklisting has to be preceded by a so-called notice. Law in this regard is firmly grounded and does not even demand but so-and-so the necessity of the compliance of with the principles of natural justice by giving the opportunity to the person concerned against action. Blacklisting is sought to be taken has a valid and solid rationale behind it. The lordship may skip up the down to 19 minutes. In the light of the above observation, it is clear that a prior so-called notice granting reasonable opportunity of being heard is an essential element of the administrative decision making, and particularly so in the decision pertaining to the blacklisting, which entails grave consequences on the society. And your lordship may thereafter come to below the next page, my lord. Para 30. Para 20, my lord. In the present case, the factum of service of so-called notice dated so-and-so by the corporation upon the appellant is not in dispute. So the so-called notice was issued. Rather, what Sri so-and-so has argued on behalf of the appellant is that the contents of the said so-called notice were not such that the appellant could have anticipated that an order of blacklisting was being contemplated by the so-and-so. In Gorkha, that was judgment which has been relied on by this court, had to decide whether the action of blacklisting could have been taken when specifically proposing, contemplating, commissioning such an action in the so-called notice. For this purpose, the court has laid down below the guidelines for the content so-and-so. Now, the guidelines you will also find in the same para 21 and 22 at the bottom below. We are of the opinion that in order to fulfill the requirement of principal natural justice, a so-called notice should meet the following 2 requirements. The material grounds to be stated, which according to the department necessitates such action, the particular penalty action which is proposed to be taken. It is this second requirement which the High Court has failed to manage. So, my lord, you issue a so-called notice to me on some other issue. You pass an order on the issue which is totally wrong, which is not at all, because I've shown to your lordship that I've never stated that I will not supply the goods for 12 crores. I'm ready. I was ever ready. I was reminding them again and again. They finally allow me release the order for the 12 crores. Now they are saying that you have stated that you will not be able to supply the 12 crores of goods. It is absolutely, my lord, beyond the reply and pleadings that, and my lord, you issue as LOA in 22. You issue me a release order for 5 crores. You accept 4.50 crores only. And my lord, in this condition is there that within 12 weeks, the goods should be supplied of the issuance of the order. Not to speak of 12 weeks, it is 12 months now. And the payment has to be made within 30 days. For months together, my lord, the payment was not made for 50 lakhs. So breach of contract is from the other side, not from my side. In spite of that, my lord, the blacklisting order was passed, and my lord, I submitted for learning single judge. My lord, that I've given a chart also, that I have participated in the bidding process of 5 bidding process, my lord, in other contents, amounting to 50 crores or something. And another bidding, my lord, tenders are there, where the last date is 24th and 25th. Now, because of the blacklisting this order, all my tenders which are there earlier, that will be rejected, and I will not be able to participate in the other bidding process which are there. In view of the prima facie order, illegal and arbitrary and violative of principle natural justice order, the order should be stayed, because otherwise the harm which will be caused to me will, or subsequently after 1 month, the blacklisting order is set aside. But the harm which will cause to me, my lord, because of the rejection of my bid, which I have already submitted, and I will not be able to participate in the further bid, it will be for 5 years. And it will amount to not a civil debt, well, not future, today itself. Today itself, the company will have to be closed. Well, it is never contemplated that a person can pass a blacklisting order, arbitrarily debarring somebody, and the court will not stay and will say that, okay, that will continue. You know, the question is that, my lord, so far as this BPCL is concerned, I can understand that the BPCL is not going to enter into contact till the issue is resolved. So it has a far-reaching effect on all the tenders. And the various high courts have said, my lord, that you cannot go beyond the so-called notice. Now, so-called notice was on a total different issue. An order which you are passing is that you have said 12 crores I will not supply, which I have shown to your lordship prima facie that I have never stated. I have stated that I am ready to supply the first purchase order, which is of 12 crores. Where from they are getting that 12 crores I am not supplying? This is nothing, my lord, at the instance of the competitors who want me to be out, not only from here, from other contacts, all, they want that orders to be there. Even if it is set aside after 1 month, the damage is already done. Now, my lord, in the damage and severity, which the Supreme Court has said, my lord, that it amounts to civic death. Now, without the final decision, if I am put to death, that you are dead, then, my lord, whether there is any chance of revival of a dead person? The death will be today itself. After 1 month, will I be set aside? I will not be revived. I'm gone. I'm out of the business itself, my lord, for 4 or 5 years. And they are not my lord, accepting the goods. For 1 year, 12 crores was there. They have accepted 4.50 crores only. And now they are saying that because you are not, you say that you will not be able to supply, a breach of contract is there. Why you have not accepted? My lord, I can understand they issue purchase order or supply order for this quantity, and I said I will not supply. Whatever purchase order was there that is lying, dispatch order is only for 5 crores. You have not issued me any dispatch order. Where is the question of refusal? Refusal can only be there when somebody asks me that you supply and I say I will not. There is no question because they have only given for 5 crores. And that also they have accepted for 4.50 crores. There is no question at all, my lord. My lord, in view of the prima facie, my lord, the order is most illegal, arbitrary, only because, my lord, an order is passed, a blacklisting order is passed. It cannot be that the blacklisting order will operate and after 1 year, 1 month or 2 months, after causing all the damages, if the, my lord, the order is also set aside, the damage is already done. That cannot be repaired. As the Supreme Court said, civil death. You are giving me death today itself.
This is a
Your lordship may record the statement, I am ready to supply. I was always ready to supply. There is no question of not supplying.
The proposed and implemented was issued by the BPCL. Otherwise, my lord may kindly come to page 370.
Is Union of India only, my lord, formal party.
Just I am indicating those. We have made a party, so I am indicating those. 375 page. Page 375, lordship, paragraph 1 itself, lordship. It says, so cause notice issued by the BPCL authority, lordship. You are hereby required to so cause in a writing within a period of 15 days. Page 375, lordship. 375, annexure 19. It's a so cause notice issued by the BPCL authority, lordship. The first paragraph itself says that, lordship. You are hereby required to so cause in writing within 15 days from the date hereof why you should not be placed on holiday list and be debarred from entering into any contract with BPCL for a following reasons. It's a so cause no specific so cause notice is there, lordship. Then my lord may kindly come to lordship and 408 lordship. 408 lordship. Last paragraph, lord. First paragraph itself says that, lordship, whereas our so cause notice dated so and so and reply dated so and so, lordship. After considering this, lordship, last paragraph. Hence, after considering the lordship, page 408. Hence, after considering the contention made in the so cause notice, your reply to the so cause notice as cited above, it has been decided that business dealing with you and your allied agencies will be banned, and you are hereby debarred from entering into a contract with BPCL for a period of 1 year, effective from the date hereof. Lordship, the required reasonable opportunity was given, adequate opportunity was given, lordship, and that particular, lordship, the impugn order is fixed by lordship so cause. The principles which was laid down by the Honorable Appeals Court, that was followed here. It is not a case that, lordship, the so cause notice was not a specific one. The principles which is laid down by the Honorable Appeals Court is followed, lordship, that the so cause notice should specify the grounds and should specify whether it should be blacklisted or not. That part is already there. It was preceded by that, lordship, the impugn order. And my lord, lordship, single judge's judgment, lordship, Honorable single judges says that, lordship, the intent will be considered in the presence of the lordship, the authority of the BPCL. Lordship may, in this, at this stage, not interfering in the interim order, lordship may demand back the matter to the single judge, they will decide it. Otherwise, lordship, the blacklisted part, debarring part is, lordship, followed by the national justice, adequate opportunity is given, lordship. It is not a case that that person has not, lordship, followed. The guidelines set by the Apex Court is followed. It's only something.
My lord. Your lordship may, the reply which I submitted to the so cause notice, your lordship find at page 377. Well, what I have stated in the reply, my lord, in the middle, my lord, we informed LP 378, the relevant one. The first paragraph, the last 4 or 5 lines, my lord, 6th line, we inform BPCL our inability to meet the so-and-so local content criteria, keeping in mind the BPCL's interpretation of the policy, and on the basis of the available raw material to meet the class 1 local supplier, local content, we inform implicit that we could cater only the first call of PO quantity under the so-and-so policy. The PO quantity was 12 crores. So we said that we will meet up to 12 crores quantity, whatever is there. Because LOA, you'll also see that it was 15 crores. And in the impugned order, they are saying that the contractual value is 12 crores only. And that we have said that we will not be able to supply it. Where I've said, I said that I will be able to supply PO order, whatever is there, up to 12 crores. And that they are referring to the PO, 12 crores. In the order, they are referring to 12 crores. I was ever ready to supply up to 12 crores. I was requesting they kindly give me the release order. The goods are lying and it is marked with the BPCL. It cannot be supplied to somebody else also. And as my learned friend said, my lord, the matter will be considered. My lord, once the bids are rejected, the matter will be taken on 6th. if the bids are rejected, I've given a chart also in my repeal, my lord. You'll also find the chart. Where I've already submitted the bid, 425, my lord.
So 24/12. See, Dr. Ashok, Leonard, single judge has not discarded the interim order.
I've never said.
There's no rejection.
No.
He said it will be considered on
After,
5th.
my lord.
On 5th.
My
After notice of.
Reopening, my lord.
So what is wrong in that
My lord,
order?
I will only submit, my lord, which is the difficulty is there. My lord, these bids which I've given on 425, tomorrow it is rejected and it is going to be rejected on the ground of the computer. My lord, this bid, once it is rejected, they will never be revived. And 25th is the last date I submitted before the court. The 25th is the last date for submission of some of the bids. And I will not be able to submit the bids. Even if on 5th, my lord, the matter is stayed, in order is said, my lord, binding order. Whatever has been done before 5th, that will cannot be revived. Your lordship may, my lord, on 6th, the court may consider. I have no objection at all, my lord. But till 6th, this don't be effective. Otherwise, my lord, all my bids will be rejected and I will not be able to participate also. And lordship is aware, if I submitted, don't fail to submit the bid in 25th, the bid will be finalized by the 8 months, 9 months. The supply will be for 2 years. It will have an effect of 4 years. Even if your lordship may passes the order that my bid, other bids should not be rejected till the consideration of the interim pay by the single judge, I should be allowed to participate in the other bids subject to the result of the orders which are passed by the single judge, but I have no difficulty. But I should not be put to civil death on the first day itself.
Do not. Okay, heard Dr. Ashok Sharaf, Leonard, Senior Counsel, assisted by B. Barol, Leonard Counsel for the appellate. Also heard Mr. K. Gugoi, Leonard CGC. For the
Well, other parties, my lord, the court directed us to submit the copy by mail, and today we have submitted, my lord, sent by mail. Because the register post, my lord, it will not reach to the court, my lord, directed that to send by mail. Your lordship again, my lord, direct me, my lord, I will again send the copies by mail and take steps also.
What appellants?
My lord,
You have for respondent number 1. 1. Stop. Para. With that order?
my lord, the impugned order,
By an order.
binding order page 406, 408, my lord.
Dated
Dated 4/12/2023.
The petitioner's company was
It's a firm, my lord.
the petitioner's firm was blacklisted by the authorities
For 1 year.
of what company? Bharat Petrol
Petroleum
Petrol
Corporation.
Limited for a period of 1 year. Stop. Being aggrieved with the order dated, with the order dated 8/12/2023, the appellants as writ petitioners preferred WBC number 7421/2023. Stop. When the said writ petition was heard on the at the motion stage, the learned single judge by order dated 2012/2023 observed that that, no, the learned single judge was not inclined to pass any interim order on the said date, and also directed that the same would be considered on the returnable date in the presence of the respondents. Stop. The next date for consideration of the interim is fixed on 5/1 to 2024. Stop. Para. Learned senior counsel for the appellant submits that the petitioner's firm has been blacklisted for a period of 1 year by the by the so-and-so authorities. Stop. And submits that the blacklisting would have a civil consequence upon the petitioner's firm. And has relied in the case of
Case 6.
UMC Technologies within bracket P Limited versus Food Corporation of India, reported in 2021 to Supreme Court as 2 SCC 554. Stop. Para. On the consideration of the materials available on the court, we find that a show cause notice was issued on the petitioner's firm, to which the petitioner's firm replied, stop, and thereafter the order dated 8/12/2023 was passed. Stop. As the writ petition is still pending for adjudication before the learned single judge, we are not expressing any merits, expressing any opinion on the merits of the case. Stop. Further, we find that the prayer for interim will be considered on 5/1/2024. In that view of the matter, comma, this writ appeal is disposed of by no. On top you say also, learned senior counsel also submits that the petitioner's firm has submitted bids in different.
Different. I've given a copy, my lord.
Where is it?
My lord, in the list I've given at page 425.
Which list? This list.
Writ appeal, my lord. In the writ appeal at page 425.
Has submitted bids under different departments of Assam,
Not Assam. These are different places.
under different departments in various parts of India. Stop. Therefore, if the said blacklisting, if the said order dated 8/12/2023 is not stayed, it would have a damaging effect on the petitioner's firm for the next 4 years. Stop. Para. Then after that you say without expressing any of and as is fixed on 5/1. This writ appeal is disposed of, directing that the bids of the petitioner's firm will not be rejected on the basis of 8/12/2023.
Certain bids are
On the basis of the order dated 8/12/2023.
certain bids are going to be submitted on 25th. The last date is there. My lord, I may be permitted to submit a bid.
Further, comma, The petitioners firm may also be permitted to submit their bids
It's
for
fine.
other works. Stop. However, this order shall be subject to the outcome of the decision of the learned single judge with regard to the interim order, which is to be considered on 5/1/2024. Stop. Writ appeal is accordingly
One word.
disposed of. Yes.
A petitioner will be allowed to submit the bid, but fresh bid, my lord.
Doesn't
And
that
this order will
defeat-
not come in the way, my lord. This order will.
Be we allowed to submit fresh bids, and the order dated 8/12/2023 shall not come in the way of the petitioner's firm.
I'm highly obliged, my lord, for giving me, I'm giving you a loss of my life. I'm to give a loss of trouble, my lord, on the. And
Let us see what happens on 5.
Why not?
All the councils, are all the councils present? So you please submit your written arguments. I'll list it on, I'll give you a sufficient time. We can list it on 19th January. then- Yeah. Give separate order like yesterday. List is better on 19th to 19th January to enable the parties to submit their written arguments. Okay.
But yeah, hello, in item number 2, we have already submitted from the petitioner side.
Yeah, the other side, yeah, the other side. has
Okay.
not- Yes, yes, that is.
Okay.
Item 2. Item 3. Item 4.
4 and 5, together will take up. This matter is solely. No, these are not done separately, but.
Lordship will again hear.
No, I would not. You submit your written argument. No, you have also in your case.
If I forgot, it was on 21/3/23, the KV was there.
So what I'll do, I'll give you sufficient time. What was
Last one, Lordship, fixed on 10. No, the last one where we had to submit a return. Let it be after vacations, Bihu vacations, Lordship.
19? 19.
I'll submit. I'll submit.
Okay, thank you, brother.
Obliged.